My lord, Soja. Yes. May be permitted to mention, my lord, one criminal appeal, my lord. My lord, the
Appeal hearing we are not adding.
my lord, I am for the respondent accused, my lord. My lord, the learned trial court, my lord, has already acquitted. Thereafter, my lord, the state has preferred this appeal against acquittal. My lord,
So you are not suffering as such.
is ready, my lord, and today in course of the day, my lord, I will serve my
No,
lord, the
no,
learned
no, no,
additional
no,
appeal.
no further addition of appeal. Yes.
My lord, kindly, my lord, let it be listed, lordship.
No, no. Next
Lordship, may I permit one mentioning, Lordship? There is an enmity matter for the inclusion in the list, Lordship.
For the first time, not hearing.
No, no.
Yes.
Lordship, item number 88 of today's list, Lordship.
Yes.
It's a appeal hearing. It's a life imprisonment, already more than 20 years in custody, Lordship. Mr. Shekhar Bosu will,
No upgradation. We have already, all the matters are urgent.
any
No,
day, any
No,
day next
no
week.
upgradation. No.
Already in custody for more than.
Understood, but no upgradation. Yes.
So one cancellation of bail and one bail in connection with appeal.
Yes. Call, please.
Permit to mention.
Yes.
Upgradation, lordship.
Upgradation, we are not allowed. Next. Accordingly, FAT 5 of 2023 is allowed on contest, thereby setting aside the impugned judgment and decree dated September 19, 2022, passed by such and such, and decreeing the said suit partially as follows. The plaintiff's appellants do get a decree of rupees 30,45,000 as mean profits, and the plaintiff's appellants do get a further decree of rupees 2,11,106.25 paise as arrears of enhanced rent for the Schedule A and Schedule B properties combined together. The defendant's respondent shall pay such sum amounts to the plaintiff's appellants within 90 days from date. In default, the respondent defendant shall pay interest at the rate of 6% per annum on the decretal amount calculated from the 91st day from this date till the date of making the actual payment. Can is also disposed of. Formal decree be drawn up. No arrest to cost. You have calculated on the basis of your new rent order for 2027, which is lesser than the amount claimed by them. They claimed higher amount as mean profits, but we rely on that document which they have annexed in their order for 2027 for calculating the main profits. Decree
Lordship,
Oh, what? Next.
Item number 2.
Yes.
Lordship, we'll take a short pass over, Lordship. Triple AG service before the writ court.
The office report indicates that the appeal is defective due to the district code on form A and pin code of the appellant, as well as the signature of the learned advocate in the prayer page missing. First up, next para. The time for curing the defect has already expired. First up. However, we extend the time for curing such defect for a week from date. First up, the learned advocate for the appellant is directed to take appropriate steps for curing the defects as indicated by the office within a week. First up, if such defects are cured within the said period,
My lord,
within 1 week.
within this day we can.
We are giving you 1 week. Do it today.
Hard.
জায়গায় 1 week বলেছি, ওটা আপনি করে দিন during the course of the day. ফাইলটা নামিয়ে দিয়ে যাতে ডিফেক্টে কিউর করে। কি তো কারেক্ট করে দিতে হবে। এটা দিচ্ছি কারেক্ট করে আপডেট করে দিও
My lord, one.
এটা কি করে দিও পুরো আপডেট করে দিও স্পেসেস চেঞ্জ করে সই করে নিও
My lord, if it is cured, then it will be next week.
লিস্টেড
The pension matter, pension, retirement.
will আরেকটা লাইন অ্যাড করে দিন subject to curing of the defects the matter be listed under the appropriate heading on June 15 2026 Monday দীপঙ্কর ফাইলটা নামিয়ে দিও ডিফেক্টটা কিউর করলে অফিসকে আবার পাঠিয়ে দিতে বলে সোমবার দিয়ে দিও
Item number 3.
One time for that. This matter, victim has not been served yet. It is in the course of transmission matter. My lord, state, it may kindly be served through state. Direction may kindly be.
Very well.
Kindly keep the matter on his here.
Well, Learned Counsel for the appellant submits that the victim has not yet been served. Full stop. Accordingly, the state is directed to ensure that service is effected on the victim at the earliest. Full stop. Let the matter be listed next on June 16, 2026. You are appealing for the state.
Yes, my lord.
So just please ensure that it's served on the victim.
My
The
lord.
police station or whatever you are. Yes.
Item number 4.
Oh, my lord, this is an application under 389, my lord. But, my lord, on the day, when it last came up for hearing, I requested the court to hear out the appeal. And the points in bail and appeal are all same. Then Mr. Mishra said on Monday or Tuesday. So from Monday I can start.
My lord, item number 4 to 9, praying for short passport.
4 to 9 are similar. You are not in, you are only in 4.
I mean 5 also.
Triple H is appearing, my lord, before the read court. That's why he has taken for
No.
5 to 7 minutes.
Is he ready for hearing the appeal?
Yes.
Ready for hearing?
No, we will not start today.
Acha.
এটা মঙ্গলবার,
ঠিক আছে।
এই সোমবার।
My lord, I will inform.
On the prayer of the appellant, let the matter stand adjourned till June 15, 2026.
Mark, I will start on hearing.
Same order in
Points
the,
are same.
well, same order in the next one also?
No,
Call-
my lord.
Call,
This bill application is there, it is,
you'll move it, yes.
Item number 5.
Yes, short matter, you do it by,
My lord, he is here.
yes, yes, come.
Yes, my lord. We are reading 4.
Mr. Vishnu, 4, we have adjourned on his prayer till Monday.
Item number?
4.
Hearing.
No, 3 and 4 can also be done. We are ready.
They are not ready.
Oh, acha.
not ready, let us, 5.
5, yes.
You start with 5.
Yes, 5, Mr. Vishnu, what is that?
Yes. But my point is very short, very brief. Kindly come to the judgment. I will court to reappreciate the evidence, review the evidence at this stage, my lord, which is also not permissible while considering an application under 389
Yes.
CRPC, my lord. The brief statement is kindly come to page 30 of the judgment, man, of the paper book, man.
Paper book টা
29, the judgment starts from here.
We are ready.
is 30.
Yes, 29, my lord, is the judgment starts.
Yes, yes.
At page 13, the
Yes.
list of the witnesses examined by the prosecutor. There are 8 witnesses who are examined.
Right.
This is a case under section 4 of the POCSO Act, a penetrative sexual assault, my lord. The doctor, on the basis of whose report the conviction was based, was not examined. The doctor who conducted the potency test was not examined by the prosecution. There is no doctor. From 1 to 8, there is no doctor. 2 doctors are required to be examined. One is the doctor who conducted the medical examination of the victim. Another is the doctor who conducted the potency test of the accused. My lord. Now, interestingly, my lord, kindly come to the next head, that is the exhibited documents. exhibited by the prosecution. The number one is the medical examination report of the victim girl. Exhibited on the basis of the signatures. Only the signatures of the mother were exhibited. She gave her consent for the examination, and it was exhibited on the basis of that only,
It was proved
without
by
proving
whom?
the content.
Proved by whom?
Content was not proved.
No, it was not formally tendered in evidence.
It has been made exhibited. It is an exhibited document. The court relied upon it.
No, how was it
Interestingly, the
exhibited?
doctor should have been examined.
Who proved it? That is what we are asking. For-
It is the signature, and thereafter it was tendered by the IO, or during the examination of the mother it was exhibited.
Okay.
Number one, my lord, potency test. I am not commenting on potency test because it matters little. My lord, about a case which is based on a penetrative sexual assault, medical evidence is very important. However, it is also settled law. When there is no medical evidence, no examination was done, oral testimony, if consistent, can be relied upon. That is the law, my lord.
Not the other way around.
Well, but when there is a document, there is the content has not been proved, but it is relied to convict the accused. It is not permissible. It is a serious prejudice. Accused should have been given a right. Accused was deprived of his right to cross-examination, my lord. This is a very serious prejudice. Another part, my lord, there is this prejudice lingering subsequently. Why? Where, my lord? Kindly come to the page number 25 of the paper book, my lord. She's a 15 years old girl.
Yes.
Well, this is the examination of accused under 313 of the CRPC, which is it is not an empty formality. It is a direct dialogue between the accused and the learned judge, where the accused is judge is required to put every question, every circumstances, documents which is going against him, and he has to answer. He should be given an opportunity to answer each and every evidence which is against him. It is a direct dialogue. It is like audio alterum partum in the criminal justice system, my lord. So, my lord, I have carefully gone through it. My lord will also find that the medical report, which was illegally exhibited, not in accordance with law, was relied upon subsequently while convicting the accused as an important piece of evidence, but was not put to the accused during the entire 313 examination. Here is the examination from 25 to
Medical report not being put to the accused.
yes, it is a
Or to
serious
the accused. that's-
to the accused. He has to explain.
Yes.
These are the injuries. Now, what do you say? What is your opinion about it? So, when there is a law is very strict, there is a presumption under section 39 against me, my lord. A fair opportunity of trial, fair opportunity of explaining the circumstances has to be given to the accused. Otherwise, there is a serious prejudice. Now, if I want to take the plea in trial, I have to demonstrate the actual prejudice, my lord. So what more can I demonstrate, my lord? I was robbed of my right of cross-examination. I was declined. The prosecution did not examine the witness. So my precious right was taken away. My lord, I am relying upon a judgment reported in 2023, volume 7, SCC 95, my lord. This is the latest judgment on the subject. They are from 1973. There are series of judgments on this point, my lord. I took out the latest one. Here in paragraph number 21 of the judgment, kindly come to paragraph 21 of the judgment, my lord. 22. This is the extract of all the other previous judgments on this point, my lord. The court has formulated the points. 22(1). To 22(8). There are 8 points have been formulated about 313, my lord. May I read, my lord? It is the duty of the trial court to put each material circumstances appearing in the evidence against the accused specifically, distinctively, and separately. The material circumstances means, this is very important, the circumstances or the material on the basis of which the prosecution is seeking the conviction, my lord. This comes under the material. This document comes under the material, my lord. This is not the circumstance. The circumstances has a wide meaning here. Everything has to be put to the accused. Now, my lord,
the object of examination of accused under 313 is to enable the accused to explain any circumstances appearing against him in the evidence. My lord, thirdly, the court must ordinarily eschew material circumstances not to put to the accused from consideration while dealing with the case of particular accused. The failure to put material circumstances to the accused amounts
Prashant, we
to
have-
serious
We have
irregularity.
read this. The last one says the delay in raising contention is one of the factors.
My
Understood. But
I am
did you-
before the immediate appellate court, before the high
Understood.
court.
But did you raise? We are just asking you.
Where can I raise, my lord?
In the trial court?
How can I, my lord? It ends it is
No,
the
no,
end.
the evidence was over when the arguments began. So at that point of time, you knew that you did
My
not
lord,
have it.
I'm
We're just asking you.
Yes, my lord. No, it was not because, why, my lord, I'm saying, after when it was relied upon, the judgment, the judge was the learned judge was authoring the judgment, it was
No,
CAV.
that we understand, but it was exhibited previously. Before arguments, it was exhibited. Doctor was not examined. You knew when the arguments were going on. We're just asking you, had opportunity.
Yes,
How the judge
doctor was
relied
not
that-
examined, that was it, and that a judgment,
Point was
that
raised.
issue has been decided, my lord, in the judgment.
How did the trial judge decide?
Learned judge referred a judgment where of the Supreme Court in 2010 where it is stated that non-availability of medical evidence is not enough, not sufficient to base a acquittal.
But here you say that it was relied on. If it was not examined, then.
Yes,
not
but that
considered.
judgment, it has a difference. That judgment does not say that it was not, it was suppressed rather.
So you say even without the, not even, without the medical report, this might not have been proved at all. Because she's 15 years old.
My
If
lord.
she was a child of tender years, then might be
Might
no
be,
injury, nothing
my lord.
in that sense. But all right.
My lord, this is my cornerstone. My valuable right is gone. Now I am raising it before the immediate higher court, my lord. This is a high court. This judgment is of the Supreme Court. It is, if had I raised it before the Honorable Supreme Court, it would have been
Mr.
would have been a
Can we
dilated.
look into that medical examination report. Is it a part of this paper book?
No, my lord. It is an exhibited document in the exhibits file only. It is there. There is no injury in the body. Only statement is there that there was insertion of the male part into the vagina several times, not once. It is a story about once, my lord. There is no body mark. There is the forceful. The allegation is of the forceful rape. There is no body mark, no cut injury, nothing, my lord. So that is the reason that was suppressed, just to base a conviction by hook or crook.
Let us hear the others.
My lord.
Yes,
This is
Mr.
my humble submission, and let me complete my submission,
yes,
my lord.
yes.
One line more. When such material thing is not put to the accused, he was not given an opportunity to explain the circumstances. My lord, two avenues are open. One, if it is a curable defect, a retrial, it has to be remanded, otherwise an acquittal. In this case, Supreme Court acquitted it because of the long delay. My lord, if there is, in both cases, if there is a retrial or there is acquittal in future, my lord, there is a fair chance of success in the appeal. Therefore, what is the purpose of keeping me in custody?
You are in custody for how long?
I am in custody since my arrest, my lord. Let me, my lord, I will. Charge sheet is not the part of the paper book. That is right. From 2022, I'm in custody, my lord.
Very. That's all.
My lord.
Yes, please.
First off, my lords, we need to understand what is the story that has gone into the fact of the case. There is this girl, my lords, who is the victim girl hearing. She was aged about 14 to 15, in between 14 to 15. This accused, the Rahul Kumar Sharma, he happens to call the girl was outside her house. Rahul Kumar Sharma house was 3 houses adjacent to the girl's house. He called the girl. The girl was going towards Rahul Kumar Sharma, the accused house. In the meantime, there is a Janak Mama. The Janak Mama, my lords, happens to be the PW number 4. This Janak Mama, who is the maternal uncle of the girl, he asked the girl, "Where are you going?" The girl replied, I am going to Rahul's house. Janak Mama said, don't go there, he's not a nice guy. Then still the girl, she goes. Thereafter, the story that is getting from the record is the accused person handed over a mobile phone and some cash to the girl. The girl, she refused it. She said, no, I do not want it. Thereafter, there was forceful penetration that happened. There are two eyewitnesses to the event because this Janak Mama and then there is another person, PW5, Ganesh Barman. They both, after hearing of the hue and cry, they came there. The door was forced open and both the accused as well as the victim girl, they were found in a compromising position on the bed. That is what the story is. Now, first, if I can have my lordship for a moment on what the victim girl has to say, para 17 at page 9 of the judgment.
Yes.
In this case, victim girl was examined as PW1, and in her evidence, she stated that on 16th of August 2022 at about 1:30 p.m., when she was alone in the house and went out of the house for a while, the accused called her to his house. When she was going to the house of the accused, Janak Mama saw her and told her not to go there. She replied that let her see why the accused called her and entered into the house of the accused. The accused offered her money and mobile phone, which she refused and tried to come out of the house. Suddenly, the accused pulled her hand from the back and dragged her inside the room. He put off his own such and also removed such and committed such and such upon her. After some time, Janak Mama went there in search of her and found the accused committing misdeed with her. After returning home, she divulged the entire incident to the mother. Janak Mama also disclosed the name, the same to her mother, and thereafter the complaint was lost. So this is not a case wherein the prosecution has to prove the story through circumstantial evidence or something like that. The victim girl statement is there. The statement of the two eyewitnesses are there. Now, if I can have my lordship for a moment on what the mother of the complainant has said in para 20, page 10. In this case, evidence of the victim girl was found to be reliable, trustworthy, and convincing. She has all along consistent while giving her statement before the learned magistrate and her evidence made before the court, and that would be from, that is a typo that is there, I'm sorry. And from her cross-examination, I do not find any exaggeration or improvement from her earlier version as far as the incident of such and such is concerned. Mother of the victim girl, who is the complainant herein, and before whom the victim girl divulged the incident for the first time, also corroborated the version of the victim girl during her examination.
Probably more important is para 21, which you have read. PW4 and 5 said they went into the room and
yes, I was coming to that. I was
witnessed them without clothes.
Because I am following the seriatim, milords. Yes, I would refer to the
not an eyewitness, whatever, she was there. But PW4 and PW5 categorically stated that they saw the person accused committing the
both of them, yes, they saw both of them there. Now, if I can, that milords has already pointed out. Now, my lordship, if I can have my lordship for a moment on the medical examination report and how it has been dealt with. Milords, para 18, page 9.
Yes.
First of milords, in the beginning, milords will see at page 3 that this medical examination report was exhibited. No, I'm coming to that. It was exhibited. This is exhibit 1 by 1 and 1 by 2. Now, how it has been dealt with by the Honorable Court, milords, if I can have my lordship for a moment on para 18. And then, milords, I will draw the distinction also in respect of the contradiction that he has raised. That milords will find is at a later point of time. In the instant case, medical legal examination report of the victim girl played a vital role in ascertaining the truthfulness of the allegation of sexual assault. On clinical examination of the victim girl, it was found and opined that penetration of her private part has occurred. Learned Defense Counsel in his argument has seriously challenged the report and finding of the medical officer, but is the settled position that finding of the medical officer holds significant importance. However, medical opinion is not considered as conclusive evidence in itself, and it does not solely determine whether a crime has been committed. It is ultimately the court which has to weigh the evidence alongside other factual and circumstantial evidence to arrive at conclusion. And thereafter, milords, one more paragraph is there that has been dedicated to this. Para 22, milords. It is the settled position that testimony of the victim in cases of sexual offense is vital, and unless there are compelling
We are not
reasons
denying
which necessitate looking for corroboration of her statement, the court should find no difficulty to act on the testimony of a victim of the sexual assault alone to convict an accused where her testimony inspires confidence and is found to be reliable. Seeking corroboration of her statement before relying upon the same as a rule in such cases amounts to adding insult to injury. The prosecutrix of a sex offense is a victim of a crime, and there is no requirement of law which requires corroboration of her statement by medical or other evidence. When the evidence of the victim is clear and explicit and also of sterling quality, conviction can be based on such testimony even in the absence of medical evidence.
In the absence of medical evidence, my lord.
Let me complete it. Evidence has to be weighed and not counted. It is the instant case evidence of the victim girl is very much clear and explicit and also of sterling quality to act upon her statement without looking for further corroboration. However, in the case in hand, there is ample corroboration of the prosecution case through the oral testimony of PW2, PW4, PW5, and strong medical evidence to establish the guilt of the accused. What actually has happened here is, Milords, that the court has found the evidence of the prosecutrix to be so clear, consistent, natural, and of sterling quality that, Milords, a lot of emphasis has been paid upon the statement given by PW1 read with PW4 and 5. Janak Mama and the another independent witness is there who has seen them in that room, Milords. Then, my lordship, another thing that had been pointed out, Milords, and that also needs to be the 313 statement that he was talking about. If I can have my lordship for a moment, 313, yes, Milords. On para 21 first, and then at para 28 on page 11 and 14. How the 313 has been dealt with by the court. The previous portion of para 21 is not that much. From the last line I am reading. Surprisingly, during his examination under section 313 CRPC, the accused did not disclose the same before the court. What he is talking about is that they came up with another story. They said that
Stolen
they got
mobile
the
phone.
stolen mobile phone. She
So
has a
that
boyfriend
is
before.
natural.
That-
That
No, which is okay. She has a boyfriend before because that boyfriend left her. Therefore, she came here. She was looking out for a new boyfriend and things like that. Surprisingly, during his examination under section 313 CRPC, the accused did not disclose the same before this court. He brought a new story about the victim girl had a relationship of a love affair with a boy in the locality named Taposh, who was also his friend, and several occasions victim girl came to his house with Taposh. He also stated before the court, as Tapas refused to marry the victim girl, she lodged a false complaint against him. I fail to understand why the victim girl lodged a false complaint involving her chastity against the accused if her boyfriend refused to marry her. So the plea taken by the defense counsel and the plea taken by the accused himself is contradictory and not believable, and is also strengthens the prosecution case and involvement of the accused in the alleged incident. Second occasion, Milords, wherein 313 has been discussed is in page 14, para 28. Para 28.
Yes.
In this case, all the incriminating materials pointing to the guilt of the accused were put to him while recording all the incriminating material. In this case, all the incriminating materials pointing to the guilt of the accused were put to him while recording his statement under section 313 CRPC, and it was obligatory on the part to furnish some explanation with respect to incriminating circumstances associated with him. The accused took the plea in his examination that the victim girl falsely implicated him, and she was refused by her boyfriend. But from the cross-examination of the victim girl, I did not find any such question or suggestion put to her. Explanation given by the accused in reply to the incriminating material put to him appears to be baseless and not at all convincing, and it also proves his culpable state of mind behind the incident as alleged. Then, Milords, there are a couple of more things which I would like to, Milords, bring to the knowledge of this court, Milords. Just two things. Para 9 and 31. There is a statutory presumption under section 29, Milords, which has been discussed by the Honorable Court. The moment, Milords, the first portion of it is complete, the burden of proof is automatically shifts upon the accused. And then the accused, through his defense and through all other circumstances, has to make out a case. In this case, what has happened, Milords, is that, if I can have my lordship for a moment, on the list of witnesses at page 2 and 3 of the judgment, the prosecution examined as many as 8 witnesses. But the accused, he did not tender any witness in respect of any of the statements or in respect of any of the corroboration that to not to corroborate, my lords, or to deny what is stated by the prosecution witnesses. That is important, my lords. Then, my lords, there is one more thing that is important. There were certain contradictions which he has not referred to. Therefore, I am also not referring it to.
We're not going
Lord-
to the entire hearing. We're not hearing the appeal.
Yes,
So the main
yes,
points you have dealt.
Yes, yes, yes.
Let us hear his reply on this. Yes,
My
Mr.
lord, about section 30, section 29, my lord, the presumption. The presumption, yes, there is a presumption under the law. The presumption triggers only when the basic facts are proved. The medical part, the medical evidence part forms an important part. That has not been proved in accordance with law. They cannot claim the protection of the presumption at this stage. The presumption, in order to trigger the presumption, all the fundamental facts have to be proved. And in a case of rape, my lord, one of the fundamental factor is the medical evidence that has not been proved in accordance with the law. And mere making exhibit of a document is not the proof of its content, my lord. And moreover, my right of cross-examination is a very precious right, my lord. Merely on the cross-examination of a doctor, a murder case may be agreed. In such a case, in such a situation, my valuable right was written. Moreover, what the honorable trial judge has written in his judgment, all the circumstances were put to me. But the document, C13 itself, it shows that this particular circumstances was not put to me. I was not allowed, I was not given an opportunity to answer. Therefore, there are two avenues, either a retrial or an acquittal murder, if it is a curable defect. In both the cases, I'm in custody since 2022. If there is a fair chance of acquittal murder, mere statement will not do. If there is no such document available, had it been a case that no such medical document was available, that would have been a different. But in this case, there was document that was technically carefully suppressed. That was not. My right was taken away.
Well, sir, we are
This is
passing
my
on.
point.
Passing on. The present application is an application for bail in connection with an appeal. Push up the primary offense against the appellant is under section 4 of the POCSO Act. Push up next para. Learned counsel appearing for the appellant places particular reliance on Rajkumar alias Suman versus State within bracket NCT of Delhi, bracket closed, reported at 2023 17 SCC 95, where the Honorable Supreme Court laid down the law on the examination of the accused. Full stop next para. Learned counsel submits that in the instant case, comma, although the report of the medical examination of the victim girl was produced and exhibited, comma, the doctor authoring the same was never examined. Full stop also, comma, the doctor holding the potency test was not examined. Full stop next para. It is argued that since the medical report is a vital piece of evidence in proving penetrative sexual assault, comma, the appellant being denied the right to cross-examine the doctor vitiates the trial itself. Full stop next para. Learned counsel submits that even in the examination of the appellant under section 313 of the Criminal Procedure Code, comma, the medical report was never tendered to the appellant. Full stop next para. Thus, comma, it is argued that such crucial lacuna in the prosecution case and the impugned judgment casts a doubt as to the involvement of the appellant in the offense. Full stop. Accordingly, particularly since the appellant is already in custody for about 4 years, comma, it is submitted that the benefit of bail ought to be granted to the appellant. So next para. Learned triple AG, comma, appearing for the state, comma, refutes the prayer for bail and argues that although the medical report was exhibited, the same was not the sole consideration in convicting the appellant. For sub next para, learned Triple AG takes the court through several paragraphs of the impugned judgment and argues that PW4, one Jonok Bormon, and PW5, Ganesh Bormon, adduced evidence as eyewitnesses of the offense. For sub next para, from the said evidence, it is evident that the victim girl was found in compromising position with the appellant on the in the latter apostrophe's room at the time of the offense. For sub next para, it is pointed out that the learned trial judge categorically observed that medical opinion may not be the sole conclusive evidence in itself and does not by itself determine whether a crime has been committed. Push up, the learned trial judge placed reliance on Madan Gopal Kakkad versus Naval Dubey, reported at 1992 3 SCC 204, where it was held that a medical witness called in as an expert to assist the court is not a witness of fact, and the evidence given by the medical officer is really of an advisory character given on the basis of symptoms found on examination. Pushed up, the expert witness, it was held, is expected to put before the court all materials inclusive of the date which induced him to come to the conclusion and enlighten the court on the technical aspect of the case by explaining the terms of science so that the court, although not an expert, may form its own judgment on materials after giving due regard to the expert apostrophe's opinion. Because once the said opinion is accepted, it is not the opinion of the medical officer but the court. Whose next para, the learned trial judge also relied on Wahid Khan versus State of MP, reported at 2010 2 SCC 9, where it was held by the Honorable Supreme Court that even though there was no medical evidence to corroborate the testimony of the victim, such corroboration was not necessary where the evidence of the prosecutrix was otherwise consistent and stood corroborated by other circumstances and the FIR. Push up next para, learned Triple AG also points out that the learned trial judge observed in the impugned judgment that while recording the statement under section 313 of the Criminal Procedure Code, all incriminating materials pointing to the guilt of the accused were put to him, and it was obligatory on his part to furnish some explanation, which he did not. So next para, learned Triple AG next argues that despite getting opportunity, not a single witness was examined on behalf of the appellant. Full stop. Next para. Upon a careful consideration of the arguments of the parties, we find that the learned trial judge, in the impugned judgment, categorically observed that although the medical examination report was furnished in evidence, the same was not the sole criterion for convicting the appellant. Pushed up, the learned trial judge, apart from relying on judgments of the Supreme Court as discussed above, independently found that the evidence of the victim girl within bracket PW1 bracket closed and her mother within bracket PW2 bracket closed, were unshaken in cross-examination, and that the evidence of PW1 was of sterling quality. Push up next para, the learned trial judge also weighed the fact that the PW4 and PW5, who were eyewitnesses, categorically deposed that they had seen the offense being committed. Push up next para, that thus, the weight of the medical report was mitigated in view of the corroborative evidence of the victim girl herself within bracket PW1, as well as two at least 2 eyewitnesses being PW4 and PW5, all of which were relied on by the learned trial judge in handing out the conviction against the appellant. Full stop. Next para, hence, the argument of the appellant being deprived of an opportunity of cross-examining the doctor who authored the medical examination report and non-examination of the said doctor pales into insignificant. Full stop. Since the learned trial judge did not rely solely on the medical report, but also took into consideration the evidence of the other witnesses, evidence of the witnesses of the prosecution in coming to its conclusions, it cannot be said that mere non-production of the doctor as a witness vitiated the trial to such an extent that that post-conviction bail ought to be granted to the appellant. First up, next para. The principles laid down in Rajkumar Supra, although well established, are thus not attracted to the circumstances of the present case. First up, next para. In such view of the matter, this court is of the opinion that taking into consideration the gravity of the offense, the benefit of bail cannot be granted to the appellant at this stage. Full stop. Accordingly, CRAN 2 of 2026 is dismissed. Full stop. The appeal be listed on June 15, 2026 for hearing.
Thank you.
Yes.
Okay, number 6.
Yes. Yes.
The second application was referred, but the same was not raised. On 17, 2026, we had got in and typological.
And
Typological mistake of in the application. And this is the third application. Your Lordship. Here in this case, your Lordship, out of on 18 to 20 of the application. And they are granted by this. And this petition was struck. Lordship, is to be considered that the case was initiated initially on the basis of a GDM. And that GDM, the limits of the petitioner was not being crossed. And that GDM.
three others were granted bail. So he must be standing on different footing.
So I am also in the better moving because of the fact.
No, can we will have it on Monday, Lords.
To take instruction.
Yes, Lords. No, actually, I have prepared the argument, Lords, but it appears that the file was incorrect.
Please come back on Monday.
On Monday, my request.
On the prayer of the learned AAAG, the matter is adjourned for the day. So when he placed the facts, you understood.
When you replace the fact that I understood, there was no GD entry, so I thought from where it is coming.
No. It's a mistake on his office.
Number 7.
Item 7, your lordships, I appear for the state. We have not received the brief as of now.
May I comment?
Admission of criminal. Oh no, bail also.
Bail application.
Oh,
It's a plain bail application. They have paid, they have not received.
it is required to be admitted. Admitted also. It is required to be admitted also.
But at first that will be admitted. Actually, it is a bail application. Because it is a special act, so I have to file the bail application in the form of appeal. So I have already, prior to admission, I have served the notice to the.
Or if they serve it upon me now and here, we will have it on Monday. I have been consistently saying that.
Can you see, sir?
No, I understand the service was there, but
No, practical difficulties. So we'll take it up on Monday.
they serve it today, my lords, we will take it upon. They serve it
Give
two in the morning.
another
I will
copy.
argue. My lords.
On the prayer of learned,
Thank you, sir.
on the prayer of learned AAAG, the matter is adjourned for the day.
Matter maybe admit, my lord.
No, we'll do it together, whatever.
I have also informed the matter to the de facto complainant because that is also a mandate of that particular special challenge.
No, due to the transition, the office of the AAAG and the others are having problems. But they are cooperating to their.
No, my lord, I have served it on 11th. Okay, I will give you. Item number 8.
Item number 8 and 9, I'm having that.
Da, okay. Is it?
Problem is, sir, the copy of the deposition I don't have. Because,
If you one time say that, why are you lingering so much? On the prayer of the appellant, let the matter stand.
Another convict here filed an appeal before. In connection with that case, the LCR has come before the honorable. I cannot get the certified copy of the deposition.
It is lying in the court. What can be done? So then that file has to go down. You are appearing in that matter also. That person will suffer then. Is it appearing in the list? What is item number? Not appearing in the list.
Two accused. In total, there are 3 accused.
Must be in the department then, if it's already. So why is certified copy not being given?
Certified copy, High Court cannot give the certified.
Who told you? Why not? Why not? It's a part of the record. Why not? We will record an order. Learned counsel for the appellant submits that since the records are already before this court in connection with a different appeal, comma, the certified copy of the deposition cannot be obtained. First of next para, the department is directed to issue a certified copy of the deposition subject to the appellant applying for the same and complying with formalities at the earliest. Let the matter go out of the list for the present with liberty to the appellant to mention the same as and when the appellant obtains such certified copy. এটা একটু ডিপার্টমেন্টকে বলে দেবে এই সার্টিফিকেট কপি আমি দিতে বলছি পার্টিকুলার এটা সার্টিফিকেট কপি দেবে না কেন পার্ট অফ রেকর্ড অফ
Number 9. 8 and 9 are connected.
8, 9 similar same
I spent the
offense.
whole night preparing the arguments, 5 pages.
No, but it cancels out. The others have prepared the whole night for making the arguments. You are
I
asking for time.
understand.
It cancels out, Mr.
It
Mishra.
doesn't happen as per my wish.
8 and 9 are
Yes, ma'am. Same.
9 also same prayer.
Who accused?
So 9 also. Very well. No, the difficulty is because you are limited in number. That's the difficulty. So if you prepare in one matter, Mr. Mishra, then the other matters you won't be able
Because
to.
these were two connected, therefore I gave a little bit more time to this. Anyways,
Same order. 10 call karo.
Item number 10.
10 minutes, the brief is not with us.
This is appeal matter, madam. I have filed a 10 application regarding condemnation of delay.
Oh,
It's a legal
delay
aid
matter.
matter. It's a POCSO case.
Delay we are allowing and admitting the appeal.
Yes, my lord. And this is a POCSO matter, my lord. I have not served on the victim, my lord. It's not required to serve, my lord. And about the judgment, my lord, you cannot want to see.
Not required to serve. I didn't know that. Let us see the judgment. But the court can always direct you.
It's my lord. And
ये तो plan कब होता है?
not required to serve. Para 32, ma'am.
Madras High Court.
Para 32, ma'am. At the time of bail hearing, it is not at the time of admission.
No, you are very well. You are not moving a bail application. Oh, so then yes, very well. Admission, right. For that no judgment. We thought at the before the final hearing also it's not. Very well. The appeal will be heard on the grounds. The appeal is admitted and will be heard on the grounds taken in the memorandum. Push up, issue usual notices, call for the records. Paper books be prepared within 4 weeks, within a fortnight from date. Push up, liberty to the parties to mention the appeal for hearing. Oh, there was a section 5 application also.
Maybe stated, fine amount 10,000.
Once, it complete corner. The component of fine in the impugned judgment shall remain state till the disposal of the appeal. There was a condonation application also.
Yes, my lord.
Legal it matter. What is the delay?
Object but no object.
Yes, yes, yes. যেটা বললাম তার পুরোটার আগে হবে যেটা এখন বলবো। The explanation for the delay furnished in the application is that the appellant was in custody during the relevant period and due to financial constraints could not take out the appeal in time. Full stop. Learned counsel for the appellant also draws the attention to the court to the fact that due to such financial issues, the appellant is conducting the present case through the Legal Services Authority. Full stop. Next para. Learned AAAG opposes the prayer for condonation. Full stop. However, keeping in view the mitigating circumstances of the appellant as indicated above, we are of the opinion that sufficient explanation for the delay has been given. Full stop. Accordingly, CRAN 1 of 2026 is allowed, thereby condoning the delay in preferring CRA within bracket DB 34 of 2026. তারপর যেটা বলুন। Yes, we are looking at the item number, Mr. Mishra.
My lordship, 17, 18 and 19 specially fixed. We are ready in all those cases.
That's a very good.
And we will do.
Let's see whether the others are ready.
Number 11.
11 was the brief has not been served.
I am appearing virtually.
Yes, Mr.
Lordship,
Sharma.
Bimol Roy is the matter. Lordship, I request this matter to be taken up on next Thursday so that I can file the condonation of delay application by that time.
On the আমের মধ্যে আছে কি জাজমেন্ট?
না
কিসের জাজমেন্ট? এটা ইমপ্রিন্ট জাজমেন্টটা? ওহো, আচ্ছা এখন দরকার নেই। ওটা বলে দিচ্ছি। On the prayer of the appellant, the matter is adjourned till June 18, 2026. Full stop. Next para. The department is permitted to open the envelope containing the judgment, impugned judgment, for the limited purpose of calculating the limitation period and thereafter to reseal the said judgment in the envelope subject to further orders of the court.
Grateful.
আগেরটা তো রেকর্ড করি, যেটাতে আগেরটা কোন নম্বর, কত নম্বর? In item 10 also we are recording that order, Mr. Mishra. এটা রিসিল করে দেবে আবার হয়ে যাওয়ার পর।
Item number 12.
I'm for the appellate.
Yes.
My lords, this appeal has been preferred, my lords, against a judgment of affirmation, my lords.
Please come a bit closer to the mic.
Appeal
Judgment
has
of
been
affirmance,
preferred, my
yes.
lords, against the judgment of affirmation, my lords.
Plaintiff, you are the plaintiff.
Defendant, my lords. My lords, arising out of a partition suit, my lords. Now, my
Preliminary
lords,
decree or final degree?
as preliminary decree. Now, my lords, before I come, my lords, to the grounds of appeal, a substantial question, my lords, I'll briefly state the facts, my lords. Now, my lords, initially the suit was filed by the respondents, my lords, praying for, my lords, declaration and injunction with regard to the suit property. Thereafter, my lords, this suit was decreed in favor of the plaintiffs, the respondents. Thereafter, my lords, the appellants preferred an appeal, and the suit was remanded to the trial court, my lords, granting opportunity to implead the legal aids of, my lords, the appellants, my lords, defendants. Thereafter, my lords, before the trial court, the respondents, my lords, preferred two applications, one under Order 1, Rule 10, and Order 6, Rule 17. Now, after Order 6, Rule 17 was preferred, my lords, the suit was subsequently converted to a partisan suit. Thereafter, my lords, a decree was passed, my lords, against the appellants. Thereafter, my lords, we preferred an appeal, my lords. Apologies, my lords, the suit was dismissed against the respondents. Due to, my lords, the reason was that, my lords, partial partition and non-gender of parties. The parties being, my lords, the legal heirs of the respondents as well as the, my lords, appellants. Thereafter, my lords, in appeal, the suit was again remanded, my lords, back to the trial court, my lords, granting opportunity to the respondents to, my lords, adduce the sisters of the respondents as party defendants or party plaintiffs, my lords. Thereafter, my lords, it was reheard and the
They
impugned,
joined the other properties also.
no, my lords.
Also dismissed on the ground of partial partition.
Yes, my lords.
So how did the first appellate court deal with
My
that?
lords, that has been dealt with, my lords. I'll come to that, my lords. Thereafter,
No,
my
no,
lords-
on the earlier occasion, it was
Yes.
remanded for the second time.
Yes,
At that point of time, it had been dismissed for partial
Partial
partition
partition.
and non-joinder.
and non-joint,
It came up in appeal, it was remanded again.
remanded again.
So how did the appellate court deal with the partial partition part?
My lords, partial partition part has not been dealt with. Only the non-joiner parties has been dealt with. And only parties were added, my lords.
Then
Properties were not added.
it was declared.
Yes, my lords. Then it was decreased, and that is, my lords, the learned, my lords, impugned
So
judgment.
your
of the trial
ground
court.
in this appeal and the first appeal was partial partition.
No, my lords. Because it was already dealt with.
So
my
what
lords.
is the ground? Substantial.
My lords, only one limited ground, my lords, of adverse possession, my lords. Now, my lords, adverse possession was
You
specifically.
have admitted that you were a co-owner.
No, my lords. We have denied their title.
Oh.
Thereafter, my lords,
If you deny the title, you cannot claim adverse possession. Adverse possession, for claiming adverse possession, you have to admit they are the true owners and that you have been in open, continuous,
my lords, we have also
hostile possession.
specifically claimed, my lords. Adverse possession we have claimed, my lords, but no issue was framed to that effect. And, my lords,
Who are the true owners according to you?
my lords, a second. No, my lords, out of 2 plots have been partitioned in this matter, my lords. That is, if my lords would kindly take page, my lords, page 7 of the impugned trial court judgment.
Trial court.
Trial court. It has been discussed in detail, my lords.
You annex this certificate copy of the evidence.
Yes, my lords.
Yes. Page 7 of the trial court.
Yes, my lord. Page 7, my lords,
Last
3rd paragraph, my lords.
Yes.
It is a further case of the defendants as the appellants that their predecessor such and such constructed a dwelling house over 8 decimal of land in suit plot such and such and started to reside in the said dwelling house. And the rest decimal of land in such suit plot was exchanged with the non-suit, my lords. I'm jumping to the next sentence, my lords. The defendants denied the possession of the plaintiffs over the suit properties. Defendant also claimed adverse possession against the plaintiffs in suit plot. That is the, my lords, subject suit property. Thereafter, if my lords would kindly comes to page 5. It is second paragraph, my lords. It is alleged that despite of making several requests to the defendants, they avoided to make divisions of shares and physical partition of the suit properties by meets and bounds and denied to give separate allotment of plaintiffs' share, and so they filed the instant suit praying for a preliminary decree, my lords. So, my lords, the possession was, my lords, exclusive and hostile, my lords.
By this, how can we find it?
My lords, if my lords would kindly seize.
Have you adduced evidence regarding the starting point of when just saying adverse possession won't
My
do?
lords,
You have
as
to-
because no issue was framed, in spite of a specific plea of adverse possession, my lords, the, my lords, in my humble opinion, my lords, the learned courts, my lords, misdirected itself, my lords. By, my lords, looking at it with a perspective of, my lords, strict, my lords, evidentiary document, my lords.
Have you got a copy of your written statement?
Written statement. My lords, it's not legible, my lords. My lords, I don't have the copy, my lords. It was not legible, so, my lords, I didn't.
So you did not look into it?
My lords, it could not be
Do
looked
you have a
into, my
copy?
lords.
Hand over.
One of the, there were 3 sets of defendants.
You are for which defendants?
Unless I'm defendant number 1, 1, 2, 3, and 4, my lords.
This for 1, 2, 3, 4.
No, 5 to 7. They are also for 5
My
to
lords,
7.
appeal has been preferred against, my lords, by all
By
the
all.
appellants.
The-
In the
Only-
trial court, I was for.
नहीं, I want to do this.
The original deed on which you relied was burglars took it away.
Yes, my lord.
And
we
the
filed an FIR, my lord.
and the sealed copy was the strong room was gutted by fire also.
To the-
Your luck seems to be very bad. So you have to consider whether you'll continuing that bad luck or let us see your plea for it. Yes. But you have also claimed title through your father.
My lord.
That was the deed which was gutted.
Yes, my lord.
Those are contradictory, please. You know the answer.
My lord, just one last, my lord.
Valiant effort, but we appreciate the effort, but no.
If my lord to tell you, sees just one page.
Absolutely.
Page 4 of the appellate court's judgment.
বেচারা ভালো আর্গুমেন্ট করছে কি করা যাবে আমরা না থাকলে yes page 4
Page 4, my lords, first paragraph, fourth line from bottom, my lords, first paragraph. The plaintiffs have got no residential houses in plot number 1059 that is the subject suit property, my lords. But in the northern portion, they have only one tube well or that they never reside in any portion of the suit land. As the plaintiffs have got no right, title and interest in plot number 901 and 1059, they are not entitled to get any decree as claimed and therefore the suit is liable to be dismissed, my lords.
that is your case.
Yes, my lords.
No possession, physical possession may not be there, but co-owner's possession is taken to be, you know that every inch of the property shared by both. They admit you to be owners. Obviously, otherwise partitions would not be maintainable. And you also say claim title through your father, but at the same time adverse possession, that becomes irrelevant. Even if you claim ownership by adverse possession the entire land, you claim adverse possession regarding a portion of the land. A joint property cannot be adversely possessed. Because for adverse possession, either you have to be in possession of the whole entire property. There cannot be any co-ownership on adverse possession. Adverse possession has to be physically in a demarcated part.
My lords.
So two ways you have a bad case. I mean, apart from contradictory, mutually exclusive pleas, there cannot be partial adverse possession of a property.
My lords, my lords submission is that an issue ought to be framed when it was specifically pleaded, my lords. It was
Yes,
not looked
but
into
there are
from the
certain
perspective of
judgments
adverse
which you,
possession.
there are certain judgments which you must be knowing that if the non-framing of issue does not necessarily vitiate a judgment in all cases.
If it is discussed, my lords.
If it is discussed, yes, but we don't find, because if that's futile, the appellate court will look at whether the conclusion is correct or not, even otherwise.
My lords.
It can supply its reason also, will not supply your reasons, but while dismissing the appeal and order of attorney will supply your reason.
My lords. Then, my lords,
That does not vitiate the trial, that is what. But very good arguments, that your best point you have argued very well. It could not be argued better, in fact, with what limited thing you have. We'll have to keep a copy of this, Mr. Borman. You'll have to hand over a copy. Please just hand over, ask somebody, your clerk, to take out a photocopy and we'll put it on the record. The present appeal has been preferred by the defendants in a suit for partition against a preliminary decree of partition. Learned counsel appearing for the appellants argues that despite the plea of adverse possession having specifically been taken in the written statements filed by the defendants, neither of the courts below framed any issue on the same and or beside such issue. Full stop. It is argued that the said omission tantamounts to said omission vitiates the impugned judgments and tantamounts to a substantial question of law. Which of next para, however, comma, on our request, comma, learned advocate appearing for the respondents hands over a copy of the written statement filed by one set of defendants. Which of next para, from the same comma, it is evident that the defendants, comma, simultaneously, comma, claimed title to the property through their predecessor in interest by way of title deeds, as well as took a contradictory plea of adverse possession. Full stop. Next para, it is well settled that a claim of title by inheritance is mutually exclusive with a plea of adverse possession, comma, since in case of the latter, comma, the defendants have to admit the title of the true owner and claim to be in open, hostile, uninterrupted possession of the property in defiance of such title of the true owners. Full stop. Next para, apart from the above lacuna in the case of the defendants stroke appellants, comma, we also find from a perusal of the written statement that the specific date and time of commencement and the manner and mode in which the adverse possession allegedly began has not been enumerated in the pleadings. Full stop. As such, comma, no amount of evidence would cure such defect. Full stop. Next para. Moreover, comma, from the tenor of the pleadings of the defendants, comma, it is evident that adverse possession was claimed in respect of a part of the joint property, comma, which is absurd. Full stop. In order to claim adverse possession, comma, the party claiming such possession has to claim actual physical and hostile possession over the entire property. Full stop. Unless the property is demarcated, comma, there cannot be any physical possession of a portion of the property by way of adverse possession. Full stop. Next para, in such view of the matter, comma, we find that although no specific issue was framed on adverse possession, comma, the same does not vitiate the impugned judgments in any manner, and it would be ultimately a futile exercise even if an issue was framed thereon. Full stop. Accordingly, comma, we do not find any substantial question of law involved. Hence, SAT 13 of 2025 is dismissed under Order 41, Rule 11 of the Code of Civil Procedure. Can one is stay?
It was already, my lords,
Already
disposed
allowed.
of.
So there is no other application.
No, my lords.
No, can 2 is there, yes.
Can 2 was
Can
leave
two
to
was
appeal,
allowed.
that 2 was
The
disposed
legal.
of. I'm grateful.
Sorry. Yes. Next.
Number 13.
There is a second appeal for admission.
Yes, Mr. Ghosh.
Millard,
Madam, for this.
this was Millard a suit for declaration of title and recovery of possession. So admittedly, Millard, the plaintiffs did not have possession over the scheduled property. Now, Millard, the trial court dismissed the suit on the ground that title could not be established. It was dismissed in totality. None of the prayers were granted. Millard, the appellate court, Millard, partially modified the decree, declaring title of the plaintiffs. But recovery of possession was not granted on the ground that the suit property is not described properly. So, Millard, against that, this appeal has been preferred. Now, Millard, in my respectful submission, Millard, the modification done by the appellate court to the extent that title was declared is absolutely, Millard, untenable in law, because the documents which were present and exhibited before the trial court was, Millard, only record of rights. And Millard, now it is well settled, Millard, that record of rights.
How did the
itself-
appeal court deal with that?
Millard, kindly takes, Millard,
Let us see
the
that portion.
appellate judgment, Millard.
Yes.
Millard, internal page 7.
Yes, we are there.
7, Millard, in the middle portion from the middle of the page.
Hmm.
When the fact has been admitted
Hmm.
that Azima Bibi was the daughter of Abdul Aziz Mia, then she had inherited her share in the property which was left by Abdul Aziz Mia. There can be no doubt regarding her title in the suit property in respect of her share, and so being the legal heirs of Azima Bibi, the plaintiff appellants have inherited their share in due course. Now, so far as this Abdul Aziz Mia is concerned, no title documents were ever exhibited.
This second appeal will be heard on the following substantial question of law: whether the learned first appellate court substantially erred in law in reversing the judgment of the trial court by declaring the title of the plaintiff stroke respondents, despite the plaintiffs being unable to produce any title deed in their name or in the name of the predecessor, comma, by overlooking the settled principle of law that records of rights by themselves do not create or extinguish title in the property.
That's all.
Any any connected application?
Stay application is there. Millard can consider it, treating it as an application in connection with appeal. Instead of Millard,
No declaration, decree, title has been declared.
title has been
Only
declared.
title has been declared.
Only title has been declared. Millard, it has to be stayed, Millard.
So it has to be stayed, otherwise you'll be dealing with the property.
Yes, Millard. That's the difficulty.
Yes. Let it remain in limbo, with stay the operation.
Yes, Millard.
We have heard you.
Yes.
Heard learned counsel for the parties, puts up in view of the appeal having been admitted on a substantial question of law, comma, sufficient prima facie case for hearing the same on merits has been made out. Puts up accordingly the operation of the impugned judgment and decree of the first appellate court shall remain stayed till disposal of the appeal. Puts up can 2 of 2025 is accordingly disposed of without any orders to cost. Full stop. You are appealing for all the.
Yes, ma'am. All
Well,
the respondents.
In view of the appearance of the respondents to their learned advocate, service of notice of the appeal on the respondents is dispensed with, and the appeal be treated to be ready as regards service. The trial court record shall be brought by special messenger at the cost of the appellant, to be deposited within a week from date. Within a week from date. Full stop. Next para. The appellant shall prepare and file the requisite number of informal paper books without comparing with the records within 6 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to mention the appeal for hearing inclusion in the list before the appropriate learned single judge as and when the same is ready for hearing.
Great.
Number 14.
Arguable question to what's Please, sir. Yes, where is he? He's there. শোনো করতে যে আছে তো না সে তো অন্য ম্যাটারের জন্য কি শোনোকে আনমিউট করে আমাদের এন্ড থেকে করা নেই তো কিছু pass over other matters are there which specially fixed matters will take some time. We won't be able to reach it. Then we are making it not today. Not today. Just making it not today, not recording any order. Yes.
Item number 15.
Well, I am appealing on behalf of the appellate.
Yes, Mr. Mitra.
No,
What is the matter about?
Yes, my lord, suit for my lord, if your lordship says this to take up my lord, this stay petition once, my lord.
Yes.
And one.
Yes.
Kindly come to page 33.
Right.
The prayers in the plaint.
Yes,
Page
Mr.
30.
Mitra.
Kindly,
Yes.
my lord, prayer A, preliminary decree, prayer B, for partition of the scheduled properties, C for appointment of survey past. Then kindly come to player D. For a decree declaring that the plaintiffs are not bound by, should be bound by the sale deed bearing
Yes,
number
yes.
such and such, dated 3rd April 1965, and deed number such and such for the year 1963, and deed number such and such for the year 1968.
Hmm.
Then, my lord, again, my lord, another deed of 65.
Hmm.
Now, they say that they were minors. Their father had sold the property. They don't say that they did not have knowledge. In this background, the suit was filed and the injunction application was made. My lord, I am occupying the property. I am constructing there. Now, initially, my lord, an ex parte identity order was passed. That was challenged before this court. The order was set aside. And it was sent back. Then, my lord, after affidavit, again, my lord, on 3rd of June, an order of injunction has been passed.
But Mr. Mitra, status quo as regards nature character portion has been passed.
My lord, I will tell your lordship, my lord, 65 deeds of 1960s, unless
True,
set
true,
aside.
true. Palpability time body, yes.
Absolutely.
Very well, Mr. Mitra, we are admitting the appeal. We are directing to serve copies. If you stay the order, it will tantamount to vacating the injunction.
May I pray for one indulgence, my lord? It's a short matter, short point is involved.
Yes, yes. We'll direct both the stay application along with the appeal to be heard without preparation of paper books. Just serve and come back.
Can I come back next week, my lord? I have no, my
Yes,
lord,
yes. Why not? Depending on you, how soon you can serve. So we are keeping it on what date will suit you, Mr. Mitra. Now, no date will suit you.
I shall manage.
Anyway, congratulations on your becoming the Advocate General. But Mr.
I
Mitra,
am okay. I am okay.
tell us a date. Give us a date when we'll keep it.
Any day convenient to the
17.
court, my lord, I shall.
17th we are keeping it. So, well.
And my lord, one leave, my lord, I was seeking, my lord, if I have left out any document, my lord, may I affirm a supplementary affidavit and, my lord,
Yeah, you can prepare a compilation and serve it along with the stay application and the memo on the other side. We'll permit you to.
well,
Because filing supplementary affidavit will take further time.
yes, yes, very good. I am obliged.
Upon hearing learned senior counsel for the appellant, we find sufficient merits in the appeal, inasmuch as prima facie it transpires that an injunction in the form of status quo has been granted in a suit where the primary relief was a challenge to several title deeds and the consequential relief is partition, whereas the challenge to the said title deeds appears from the face of the plaint to be palpably time-barred, thus vitiating the maintainability of the suit itself. For next para, this appeal will be heard on the above question and the other grounds taken in the memorandum. For next para, the appellant shall serve copies of the memorandum of appeal as well as the two applications. No, one. As well as can one of 20, yes, as well as can one of 2026 on the respondents indicating that the appeal and the serve on the plaintiff stroke respondent numbers 1 and 2, indicating that the appeal along with the application shall be taken up for hearing on June 17, 2026 under the heading Specially Fixed Matters. First up, the preparation of paper books and calling for the records is dispensed with. First up, next para, leave is granted to the appellants to rely on further documents at the time of hearing, if so deemed necessary, upon serving advance copies of a compilation of such documents on the respondent numbers 1 and 2 along with the memorandum and the application. First up, next para, service of notice of the appeal on the other respondents is dispensed with. First up, the appellant shall file an affidavit of service on the returnable date. It will appear as specially fixed, Mr. Mitra, so that we can take it up early.
I am deep.
Deeply. Thank you.
Number 16.
Discussion appear করছে না। কি বলবো? Last chance দিয়ে দিচ্ছি। None appears for the appellant at the time of call. Full stop, next para. As a last chance to the appellant to move the restoration application, comma, the same is adjourned for the day.
Item number 17.
Yes.
Yeah.
We'll hear Mr. Mukherjee. We've not heard him for a long time. Yes, yes, what is that? No, we're just joking. You are competent, very competent. Please argue the matter.
My lord, first of all, my lord, I will argue, my lord, regarding the company. That 10-year imprisonment was given and he is in custody more than 8 years.
No, but you are arguing the appeal itself. So that becomes irrelevant now. What charge? 302 or 4? Section 4 of POCSO.
My lord, no eyewitness.
6 also, sorry.
My lord, completely upon circumstantial evidence.
First, let us get prejudiced. What was your age? What was the victim's age?
My lord, it was
38, 3 years.
So we're already prejudiced. So start from there. Yes.
my lord, please don't go on.
No, we won't. As a way, we will not make loose comments. Please argue. Yes.
There is no eyewitness. My lord, the
Yes.
main complaint is that
Any family dispute or prior dispute made out by you?
present applicant, my lord, is a Sabjiwala. In the DW1, he has stated in his statement that due to the business rivalry, a false case has been lost by another person who has influenced the mother of the victim girl.
Mother will level charges of
DW1
regarding her own daughter, 3-year-old daughter. She'll
My lord,
anyway.
my lord,
Let us see. Let us. You say no eyewitness.
no eyewitness.
In these cases, there may not be eyewitnesses.
No, the eyewitness is there.
My lord, the main case is that in the FIR she had stated, my lord, may I read, madam?
What are your best points?
She has stated that this person was a Sabjiwala, my
Who
lord,
has stated?
the mother of the victim girl.
Yes.
And
She was PW. She was PW.
One.
Yes.
my lord,
I'm so sorry, not PW2.
complaint. My lord,
Mother is PW2.
starting with the complaint, madam. Page number 2 of the paper. My lord, she has got
Don't make it too long. Try to be short.
different statement in 164 complaint and also in the cross examination. My lord, page number 2, my lord.
Page 2, yes.
My lord, the main portion I am reading on that moment. Fifth line. Ramashankar Shah living nearby our house. Plants also Emma shop intruded into our house and committed the intercourse with my 3 years old daughter following of his blood was coming out of my daughter genital. My lord, the condition of the daughter was getting worse. I admitted her in Shodor hospital. This was the complaint she lodged. My lord,
She says she saw him commit the.
Yes.
my lord, kindly. Yes.
Yes.
Chart, my lord, page number 9. My lord, page 10 is the main person, Chandra Kishore Koshal. My lord,
No, first, would you like to point out the discrepancies in her? Then let us go one by one. Complaint you have placed, her version. Let us see her 164 as well as cross-examination. First, let us cover this point. Then we'll come to the other witness. Yes, 13.
my lord, kindly come to page number 14, my lord. On 22/7/2018 Sunday afternoon, one Ramashankar Shah came to our house for taking liquor. Along with my husband, I requested them not to take any liquor at my house, but they did not pay any bill. And at that time, he said that certainly get paid. Now, he altered her submission alert. After taking huge liquor, my husband was unconscious and was sleeping. My lord, her husband was present at that room, my lord. On that time, my baby, Ria, was in my room, which is situated in the first floor, and I went for toilet in the ground floor. Certainly, I have heard a view of crying of Ria in loud voice from our room. I immediately reached there and found the blood is oozing out from her vagina, and I also found blood in the right hand of Ramashankar Shah. I asked him about what he had done with my baby. He did not give any answer, but he away from out of the house, immediately washing his hands. I want justice. My lord, kindly, my lord, our husband was present, very much present in the room.
Not in the room.
Yes, my lord. That in the room, my lord.
Baby Ria was in my room, which is situated on first floor. She doesn't say that that was the same room where your husband was.
Yes, my lord.
What does it say?
My lord, on 22/7/2018 Sunday, one Ramashankar Shah
Came to house taking liquor with husband. Husband was unconscious and sleeping after taking liquor. At that time, baby Ria was in my room, which is situated on first floor. Does not
The
say
husband-
at
the
any
husband
place
was-
of
The
any
husband
place.
was also on the same room. That is there. That is there. Page 13, para 1.
Good. Thank you.
My lord, he was very much there. My lord,
Page 13 where?
Page 13, minutes, para 1. Oh, I am referring to the judgment, minutes.
Oh, no.
Page 13, internal page 13 of the judgment.
No, but from our
Yes,
evidence.
yes.
Anyway,
it has come
let
up
us
later.
see the section 164 now.
this one, my lord, section 164. Now I am coming to good. My lord, page 20. May I read, my lord? Page 20.
Yes.
of the paper.
Yes.
The incident occurred on 22/7/2018 at about 4:30 p.m. At that time, I myself, my husband, and the victim girl were present in our house. My husband was lying on the bed. My lord, can you see? My
Yes,
husband
yes.
was working.
Right.
The victim girl was staying inside the room. At that time, the accused came into our room. I went out of the room in order to go to toilet downstairs. When I came back after 10 to 15 minutes and go inside our room, I found the victim girl crying on the bed. I found blood stain on the both hands of the accused. I noticed the blood was oozing out from the private hand of the child. My husband initially did not notice, and he was still lying on the bed. When I
Yes.
brought out time, he got up and saw what had happened. My lord, kindly, my lord, see. The accused then and there flew away from the room quick. Thereafter, we immediately took the victim girl to local doctor, who is known as Damo doctor in the locality, who referred the victim girl to nearby Eden Hospital, Darjeeling. The victim girl was treated in the same hospital. She remained admitted for 3 days unconscious in the state hospital. I lost the complaint against the accused on the following day of state incident. The complaint was signed by my elder daughter Kajol Shah. My lord, elder daughter has cried, but she was not present at the house. Never she was there, nor she know anything. Her just suddenly, my lord, Kajol Shah's name she has dictated. I only put my thumb impression on the complaint. after the content of the same was read over minutes.
We'll carry on after 10 minutes from here. Yes, Kajol Shah, elder daughter did it. I mean, lodged the complaint. She was illiterate, she told her elder daughter to do it. So what's the difficulty in that? LTI, yes. What else can she do? I mean, she's illiterate. She's put in a thumb impression. That doesn't vitiate anything. Acha, let us see. Let us see.
After recording the statement, my second witness
Where there?
read over to me and my lord, in 164 statement, the witness are back home. And at time from the statement of the father inside the room. My lord, page number 20. I am the father of the victim girl. He is aged about 20. She is aged about 3 years. And a younger daughter. The incident occurred 2-3 months ago. On the day about 4 p.m. the accused came to my house. We observed immediately what we both were taking alcohol. I got drugged and lay down on my bed. Suddenly, I heard the crying of the daughter. That the victim was holding her trash and found the blood was leaking out from the private room. My daughter was taken to the local doctor by my wife. I stayed back at my home. The accused is present in the court identified. I do not remember the name of the accused person. But he was taking liquor with him. We don't remember the name. I know the accused for the last 3-4 months. I am the permanent resident of Bihar, but at present I reside at home. The accused person also resides in the place nearby. Since my childhood, I have been residing at home. The accused person resides home for last 3-4 months. I made the accused for talk, which includes the date of incident. On both the occasions, I made the accused at my home. The residence in which I reside at home. Another person to his house and
Having liquor, knew for 3-4 months, but doesn't know the name. Very well. Yes.
Kindly state at the come to the last portion, madam. Page number 25, madam.
Read will catch up.
Thank you. Saw the accused inserting the finger. Suddenly he saw my. In every situation, it was stated that he was sleeping, he was drunken, but in front of him, everything is happening. And being the father, he was seeing the scene. Thereafter, I sat down. And by seeing the incident, he sat down. I tried to save my daughter, same difficulty.
Could be saved.
Yes. And thereafter I saved my daughter, and thereafter I sat down, and thereafter I kept on sitting. I did not do anything else. My lord, he is a father. I did not take the child either to the doctor or to the hospital or to any place. Police interrogated me in connection with the incident. Police came to my house on 23rd-24th of said month when I was drinking inside my home. My wife was dying lots outside. Remaining 3 daughters were with my father in my shop.
It was not dying outside, drying clothes outside. I could not have been dying outside, yes.
My remaining 3 daughters were with my father in the shop. My lord, kindly see, my lord, the totally, my lord, the story is forgot. Because, my lord, everywhere her wife stated that her husband was inside the room. My lord, he is the main person, my lord. If, my lord, according to my learned senior said that eyewitness is there. My lord, neither his 164 has been recorded, my lord. Suddenly he has came in deposition and said that he was seeing the same. And my lord, he did not save his daughter. He was sitting. My lord, now come to page number 18. The victim was dead. My lord, kindly see, the victims are neither not identified the accused person. He must have identified who has committed the same. My lord, everywhere the accused person was identified, but the victim did not identify. My lord, may I take one? I have come with my mother. I am eating a chocolate now. Chandu Bhaiya. My lord, that is the neighbor that I have said. My lord, the main portion is I know Pintu Bhaiya. The house of Pintu Bhaiya is situated at Sukhia Road. I know the father of Pintu Bhaiya. My lord, father of Pintu Bhaiya, she is taking the Rama Shankar, that is that. What has Pintu Bhaiya's father done to you? As she said, Pintu Bhaiya's the father name, Nikal Diya. And why is saying that she wanted out her child? Cross examination, mother. Not the fact that did not know Pintu Bhaiya and his father, or the fact Pintu Bhaiya's father did not cause any belief in my private. My lord, kindly see, my lord. My lord, Pintu Bhaiya. My lord, kindly note that because this appellant did not have any son naming Pintu.
Where do you get that?
PW1. $45.
Yes.
The accused person is the father of my tenant. My lord, he is the landlord. The tenant is Pappu Shah. My lord, currently, my lord, Pappu is the name. But everywhere, my lord, my mother's statement in the
Was any suggestion put to him in cross-examination? Pappu is Pintu? Or in anybody's cross? Must have been put.
in cross-examination, there is a business rivalry between Pappu, that is the son of the accused, Chandrasekhar Vishwanath Shah, that is the father of this, and Chandrasekhar and Pappu Shah run similar kind of business, and they have business library. It is a fact that Chandrasekhar Vishwanath filed this case against this accused. Cross-examination. Page number 46.
No, what is the cross-examination of DW1? 46 is DW2 cross-examination. কোথায় গেল বলছে কোথায় গেল Is it there in the, you can find from the records. If you have a copy of that certified copy, you can take it.
I have only given this paper with them.
So you prepared on this cross-examination of DW2 as DW1's cross-examination? Good.
My lord, but this is a very important.
Ashma, kindly refer to page 45 for a moment.
Yes. Yes.
But therein the accused person is the father of tenant. My tenant is Pappu Shah. the incident occurred on such and such. Now, if I can have my lordship.
No,
what more-
Mr. Don't make your submission, Mr. Mishra. No, we'll hear you. On merits letter, complete.
Business have been written in page number 45 also.
Hmm.
7th line. Chandra Kishore and Pappu has a business rival.
Chandrakishore, who is Chandrakishore?
Laborer with whom the victim girl came to the for deposition while eating the chocolate. I have come with Chandru uncle, written manner there. That person. That is the main victim, and the main person.
Chandrakishore, the girl's, victim girl's neighbor had a quarrel with the accused son.
Also, his her father, Nalad, they both run similar kind of business. I have written over there. The accused
There is no case made out that the victim's father had a quarrel with the accused.
come to page number 46 on another detail.
Yes.
I know the accused his son has a shop in our locality. I have a shop adjacent to shop of his son. I know Chandra Kishore. His shop is just opposite the shop of
Business rivalry between Pappu's son of accused and Chandrakishore.
Vishwanath Shah, madam.
Vishwanath Shah is the father.
Yes.
Hmm.
My lord, and now I am referring to page number
Page?
47. My lord, kindly come to page number 49. 49. Question number 8. CW2 identifies three state that your name is Rama Shankar and you
Which question? Which question? 8, right.
You are known as UK Papa.
Who is this? Whose witness? Which? Oh, 313. This. Acha. Yes.
I do not know that I am known as UK Papa. My son's name is Abhishek.
Abhishek Kumar is the formal name, but Pappu has already come out. So Abhishek is Pappu.
Never cited, my lord. Pappu, my lord, kindly see.
We are already confused. Pappu is whose son?
Pappu, my lord, the landlord has said the Pappu Shah's father. And
What is your stand? Pappu is the son of this your client. So Pappu and Abhishek are the same.
not me.
Or Abhishek. Abhishek আছে Pappu আছে রাহুল গান্ধী আছে Abhishek. Yes, very well. Next.
My lord, now I am referring to some of the judgments. Passengers.
Yes.
Up paragraph.
Yes.
He said the applicant has been in the jail and the total fee he has paid in the jail so far is about 4.5 lakhs. Mind read.
This is for bail. We are hearing the main appeal. Why are you citing this?
Due to long custody.
So we should acquit him. We are hearing the main appeal against the conviction. So you have 2 or 3 points. One is that, if you understood it correctly, one is that there is contradiction in the version of the mother of the victim and the father also. First of all, the mother said that he included in the complaint. But in the other evidences, it has come up that he was having liquor with the father of the victim girl. So that's different from including and committing the offense. First. Secondly,
She has seen committing the offense. My lord,
no, she has not said. She went to the toilet. She can.
my lord, the child being has fallen down because she was playing over here, my lord. And
No, that's different. That's different. Let us come one by one. So therefore, there's a contradiction in the version, inclusion or having liquor. Secondly, victim's father was present, admits to be present, saw but did not do anything, tried to save but sat.
child, my
Tried to no, tried to save, same. Tried to save does not carry any meaning. Must be tried to save. So even then he sat tight. They did not do anything, which is absurd. Very importantly, victim girl herself did not identify the accused, but said Pintu's papa committed it. There is nothing on record to show that Pintu ka papa is this accused.
everywhere, my lord, the
Pappu Abhishek, two names.
said that the son name is Papusha, not Pintu. My lord, furthermore, my lord, in the statement, it has been stated that it's a trying to come, my lord. They used to reside in a flat of fourth floor, my lord. None of the neighbor has been seen this Rama Shankar Shah to come into the house and furthermore, my lord, he was not the resident of that area. That was also stated by the fathers.
But he was a vegetable vendor there. That's an admitted question.
His son Papusha, not he.
Where is that evidence?
DW1 page number 42. Correct time page number 46. So, page number 45, my lord, at his person is the father of my payment. My payment is Papusha. The incident occurred.
No, where did he state Pappu does not reside there?
Pappu is not Rama Shankar, my lord.
You said Pappu does not reside there.
Pappu reside, but Rama Shankar resides at Bihar.
Where is it stated?
My lord, in the statement,
Sells vegetables there.
Papusha sells vegetables there, but
Oh,
his father resides at Bihar. For visitation, he has come to his son's house.
where does it? Acha, accused came to this place from Bihar about 1 week prior. So there is no doubt that he came from Bihar to meet his son or whatever.
He was present or not, that is a doubt. Because Pintu ke papa is not here.
Very good. What else? Judgments, that bail judgment is the only judgment you're citing.
Judgments I will be referring.
No, will be. We are hearing it. Yes, need not cite judgments, not necessary. Yes.
If I can have my lordship for a moment on page 64 of the paperwork to begin with. And then, my lords, I will come to this controversy regarding Pintu ke Papa, which is at page 12, internal page 12 of 17. But I will start with internal page 9 of 17, which is at page 64 of the paperwork. I am referring to the 18th line from the top. It starts with therefore. It's just above the sleeveless. Therefore, on critical analysis of the evidence of the victim girl, which is fully corroborated by her statement recorded under section 164 of the CRPC, as well as the medical evidence, it can be safely concluded that the victim girl sustained bleeding injury on her private parts due to insertion of finger into it by the man whom she refers to as father of Pintu Bhaiya. Now, it is to be seen what evidence has come on record with regard to identification of the father of Pintu Bhaiya and under what circumstances the entire incident took place. Clearly, the victim girl did not identify the accused, as the accused was not shown to her in the course of her deposition. Why did the Honorable Judge did so, Milord? Because she has already been through a lot of trauma, 3-year-old girl. Therefore, Milord, it was done. It is simply because she could not be allowed to relieve the trauma she has already undergone in the process of identifying the accused. Now, according to the prosecution case, the incident occurred on 22 July 2018 at around 4:30 p.m. at the tenanted premises where the family of the victim girl resides and the accused who came to their house at the time committed the offense. Then, Milord, I will straight away take my lordship to page 11. She was initially taken to one Dr. Dabar, who is there, who is a local doctor. And then thereafter she was, or before that, page 10, the second paragraph. Because PW2 statement is very important. She's the mother. She's the one who has seen everything. Because she went down to the washroom, when she came back, she's the one who has seen it. The mother of the victim girl, PW2, stated that on such and such, at about such and such, her husband was present in their house and at the time the accused came into their room. PW2 went out of the room in order to go to a toilet, and when she came back after 10-15 minutes and got inside the room, she found the victim girl crying on the bed and the accused with blood stains on both of his head. She also noticed that blood was oozing out from such and such. Her husband did not initially notice the incident and was still lying on the bed. PW2 burst out crying. He got up and saw what had happened. The accused then and there fled away from the room. Thereafter, the victim girl was taken to a doctor who is locally known as Dr. Dabar, who referred the victim girl to Eden Hospital, Darjeeling. PW2, which is again the mother, stated that the victim girl remained admitted in the said hospital for 3 days. The statement of PW2 was recorded by the London Administrator under 164 CRPC, and the same has been proved in evidence as Exhibit 7. PW2 identified the accused present in dog and stated that the accused is also known as Pintu ke Papa. The witness was also subjected to, yes, I'm coming to that. The witness was also subjected to cross-examination, in course of which it has transpired that the accused visited the house of the family of the victim girl on 2 occasions, once prior to the incident and thereafter on the date of the incident. It has also transpired that the husband of PW2 is in the habit of taking alcohol, and on date of the incident, he and the accused were taking alcohol together in their house, and after drinking, they were having some heated discussion. PW2 also stated that the accused came to their house at 4:30 p.m. The father of the victim girl, the husband of PW2, was examined by PW2. He stated that the accused person came to the house at 4 p.m. and thereafter they consumed alcohol. Now, if I can have my lordship for a moment, on Miller's page 12. In the middle portion, again PW2 deposition is being referred to. PW2 also stated in a deposition that the accused is known as Pintu ke Papa. There is no cross-examination by defense on that score. In course of cross-examination of PW2, no denial was also suggested that the accused was no son named Pintu. Accordingly, I fail to accept defense argument that the accused has not been identified by any witness. Though there is no direct evidence forthcoming from PW2 and PW5 that they witnessed the accused inserting such and such, but their evidence taken together with evidence of the victim girl as well as the medical evidence leaves no room for doubt that the accused such and such into such and such of the victim girl, causing tear and vaginal bleeding. Now, there is a second argument that has been raised. That is with respect to the business rivalry that has happened there. If I can have my lordship for a moment on page, internal page 14, the first paragraph. The page 69 of the paper book. So far, I'm on the second line, Malaship. So far as the present case under discussion is concerned, the accused has taken contradictory position to prove his innocence. DW1 stated that the local shopkeeper Chandra Kishore Prasad and the son of the accused had a business rivalry, and accordingly, Chand Kishore has instigated the father of the victim girl to file this complaint against the accused. The same version has been reiterated by DW2. However, in course of examination of the accused under 313 of the CRPC, the accused himself did not state the name of Chandra Kishore Prasad or his purported role to instigate the father of the victim girl to entangle the accused in this case. Further, no suggestion was given to the complainant, the mother of the victim girl, that she falsely implicated the accused at the instigation of Chandra Kishore Prasad. On the other hand, suggestion was put to Chandra Kishore Prasad during his cross-examination that there was bitter relationship between accused and the father of the victim girl, out of which the present case was initiated. PW4 was not cross-examined. PW4, my lords, again happens to be Chandra Kishore Prasad. So Chandra Kishore Prasad was never cross-examined, touching the issue that he instigated the father of the victim girl to lodge the false complaint. Therefore, the entire material brought on record on behalf of the defense does not give any clear picture as to what the motivation on the part of the family of the victim to falsely entangle the accused in a criminal case. Then, my lordship, a little bit of more observation on the same thing is there. And then, my lords, lastly, I will come to the presence of the father also. My lords, if I can have my lordship for a moment on yes, internal page 12, para 3. Oh, the para is not there here, but what I was referring to was
Above pin to Papa.
para 3. No, that I was trying to impress upon the fact was that because the parent was there, because she raised the point that the father was there and
Not
still the
that
incident happened.
Yes.
That is not improbable. That has been dealt with by the judge. Because
He was in
what
a
happened
drunken-
in this case was
drunken
this
stupor.
person, he came with 2 bottles of liquor. They consumed the liquor together. And thereafter, my lords, the father of the victim girl, my lords,
If you have a father like this, you don't require an offender.
I understand that. My lords.
Yes.
He became unconscious and he was lying on the bed. When the mother came and when she made the hue and cry, then the father woke up. That, my lords, is the story.
But father in his evidence stated that he saw him fingering the girl.
Yes, a little bit of, but the court has
He was
dealt-
still in a drunken stupor when he came to the box.
The court has actually dealt with it. That there is this minor discrepancy here and there, but that the court has dealt in the judgment.
All right.
There is just one more thing, my lords. At para 16, there was a difference. Page 71 of the paper book.
Page 16. When
Internal page
your
16.
friend says para, it means page.
Page 71 of the paper.
Yes.
Because there in
Page 16. Yes.
Yes. Second line, all such witnesses have stated without any ambiguity that they noticed that blood, because what happened was immediately after the incident happened, she was carried to a neighbor's shop. Therein people, they all gathered. And there are more, in total, my lords, I will just let my lordship know. This, my lords, happens to be PW4, Chandra Kishore Prasad is the local shopkeeper. In his shop, my lords, everybody gathered. The child was being carried by the grandfather. So everyone there has witnessed this. All such witnesses and their depositions are also there. All such witnesses have stated without any ambiguity that they noticed that blood was oozing out from the such and such of the victim girl. The private doctor, PW12, my lords, again happens to be Dr. Babar, who is the Dr. Dabar, I'm so sorry, who is the local doctor. PW12, who is surely an independent witness, substantiates such facts in the evidence. So far as the involvement of the accused is in committing the alleged offence is concerned, the prosecution case is based on direct evidence of the victim girl and her parents, and therefore it is not incumbent upon the prosecution to prove all of the chain of circumstances and the conversation that has taken place in the shop room of the grandfather or such and such. Then, that we have shown. Then, just one more thing I wanted to point out. Oh yes, the another point was that the victim couldn't identify the accused. That, my lords, I have already dealt with, my lords. I have shown it to my lordship. He was not brought at the time of the deposition, my lords. That, my lords, happens to be the reason. In total, my lords, the prosecution has 18 witnesses. Out of these 18 witnesses, my lords, everyone has corroborated the story that has been put forth by the PW2 and PW3 and PW5, my lords. There is certain inconsistency, yes, in the statement of the father, which happens to be PW5, but my lords, that alone is not enough, my lords. The prosecution otherwise has proved the case, my lords.
Yes, any reply?
My lord, first of all the neighbor has statement given their evidence. Nobody has seen that.
About the blood oozing out, yes, they saw it.
My lord, not by that way. My lord, he made.
Carapiet's case is applicable. Then did you produce any counter evidence to justify why blood was oozing out or something of that sort? Something else might have been done. Any medical evidence that this can happen otherwise also? Anything? Or cross-examination of the doctor to say that? Did you cross-examine the doctor to elicit a suggestion, that elicit a statement that it could happen otherwise also? You have not denied that you were in that house. There, we don't see any denial. Denied everything, blanket.
He has said that when the lady was coming with the child in the to her grandparents.
Have you categorically denied that you did not go to that house on that date? You are not drinking in 313.
He has said that I was that time in my vegetable shop. When I have seen that lady was coming with a child, I was there and I didn't go over there because I am new over this place, and my family members said that don't go anywhere else.
Yes, page 29, what you were saying?
Page 30. The patient was first checked by some other doctor at the emergency before her admission. I did not seek help from any other doctor by treating the tear of the vagina of the girl. On 24/7/2008, maybe the girl could have sustained similar kind of injury and had been hit by such age accidental, but that thing must have a kind of penetration. Page 30 by the doctor.
Victim girl has denied that session was put to her in cross-examination. VG has denied that she fell down and sustained.
Not denied, she has stated that the Papa has.
Not a fact that I sustained injury causing bleeding from my private part as I fell down on my toys scattered on the floor. That was the question put to her. এটা তো ঠিক আছে 3 বছর বাচ্চা এতটা চাকরি দিয়েছে বাপের ভগবান
Three things, my lord. One, my lord, Papa is not the applicant. My lord, his son name is given statement by the landlord, my lord, Papusa, not Pintu. Secondly, my lord, when a victim girl, my lord, the little girl, my lord, my lord, must have seen someone, my lord, and always during the time of deposition, that person is present before the court. She has not identified the same. My lord, thirdly, my lord, in 313, my lord, the appellant said that when the lady was coming with her child, my lord, he was at his vegetable shop only, my lord. And he saw that the lady was coming, but he did not go.
He said that he was sitting in the vegetable shop. He was selling vegetables. But your evidence says his son sells vegetables. He came from Bihar to look after his.
It is my daughter's shop, my lord. When I am coming from Kolkata to Jalpaiguri.
These are stories you are making up from the bar, not in your evidence.
Yes, my lord. It is
If you are, let us see your 313. Let us come back there. Page 14. No, not 14.
47 starting from.
Oh, 47.
Kindly come to page number
313. 50.
question number 10, madam. I am reading the answer. You have to go to the paper controller of the family of the and of those of which he says that the initial property 27 years about 4 years. At that time, he was sitting in the shop. Secretly, he goes to the teacher of the
Before question 11, he says, answer, at that time, I was in my shop. My shop.
shop that we want to stay here.
So that is also contradictory. You came here to visit your son and he says his shop.
I also found a vegetable girl coming to the vegetable shop to talk.
If you had come to visit your son only a month back, already you had a quarrel with the neighbor of such a high pitch that the neighbor convinced the father of his friend, his friend, the father of the victim girl, to raise such a serious allegation. And you convinced the mother also.
Or his son. Pappusha is his
Pappusa is accused son. My son has a quarrel with somebody. That somebody convinces his friend, not even friend, friend's wife, to go and lodge a complaint with her daughter. Such a friendship that I'll put my daughter to the dogs. Is it credible? Do you think it's credible? As an officer of the court, we are asking you, is it credible that somebody's friend has a tussle with somebody's son, and to incriminate that father, not even the son, then the son could have been incriminated. Pappu should have been, the allegation should have been against Pappu. Chandranath convinced his friend to lodge a complaint regarding the friend's daughter, not even the friend. Friend was sitting tight having alcohol. The wife of the friend, such a friendship that they convince, the friend convinces the wife that, see, I have a trouble with somebody's son, so incriminate the father. Then the Pappu would have been the victim of the conspiracy. The allegation would be against Pappu. Why should it be his father? Anyway, you have tried your best.
and he is in custody for more than 8 years.
He will be for some more time.
Yes, my lord, in his
2 more years, it will pass like a flash. Hearing is concluded. The matter is reserved for judgment. We are reserving. Thank you. বলেই দিলাম এভাবে দাঁড় করাবো দেখবেন। হ্যাঁ, থ্যাংক ইউ। ছোটবেলাতে ডিকটেশন দেবো কথা, তোমার ইয়ে আছে, ইয়ে থাকবে, আমার প্রিয় বেড়াতে যাচ্ছে, প্রিয়টা বেড়াতে গেলে তাকে রাখতে হবে, ডিকটেশনটা দেবো।
surname is not
Surname is not Pappu. Pappu cannot be a surname.
son.
Son's name is Pappu, yes. That is what we asked you.
The victim girl and her mother stated Pintu ke papa.
Yes. Right. PW2 identified the accused as Pintu ke Papa. The mother identified the accused as Pintu ke Papa. All along said Pintu ke Papa, accused, identified the accused. Next. Yes. You have a larger file than yourself. Yes. Take the microphone, Ms. Shortcut, so that don't get disheartened. You argued very well. But if your client does not have a case, what can you do? You have argued very well. Yes, Ms. Shortcut.
Summary of the incident.
Take the microphone a bit closer. Microphone, mic. Yes. Summary of the case.
The summary of the case is that this is a murder case, my lord. The FIR begins with a fact stating about extrajudicial confession. Thereafter, the prosecution carries with that story. Later on, changes the story into last seen together theory. So, my lord, let us see now. The case, the FIR is at page 2. And the allegation is against the husband.
Yes.
Yes. The complainant over here is the brother of the deceased. His name is Pankaj Bormon. I do hereby lodge the complaint in view of the following fact, that my sister Shobita Bormon got married with the following accused person about 10 years ago, maintaining social rights and custom. My sister, aged 28 years, is the mother of 3 children. My sister, along with her husband, came to our house 10 days ago for a visit. Today, in the evening, at about 7:30 o'clock, the accused Shochin Bormon called my sister from my mother's room on the pretext of visiting the road and went outside the house. About 40 minutes later, the accused called my mother over telephone and informed her over telephone, your daughter has been lying dead in the banana garden on the western side of the house. Bring her. I have killed her by throttling. On hearing this, my mother started yelling and running towards the banana garden. And I too rushed behind my mother and saw that my sister has been lying dead in the banana garden. At once, I picked up my sister into the van and brought her to Nishiganj Primary Health Center. And the doctor were on due examined my sister and declared, your sister had died before reaching the hospital. This is the fact of the instant case, my lord. Now, my lord, if your lordship sees, it's based on extrajudicial confession stating that the accused called the mother over telephone and informed that I have killed your daughter. Now, if your lordship now...
This is the complaint. Why do
This
you
is called
say
the
extrajudicial confession?
FIR.
Extrajudicial confession in the sense that this telephone call.
Over telephone call. And
This is not a confession. This
No,
is
it's an
this is a
extra-
version of the complainant.
It's a version of the complainant, my lord, and this has been taken into evidence as extrajudicial confession, my lord. Now, my lord,
How can it be a confession? Confession, I incriminate myself, that is confession. I admit something against myself.
yes, my lord.
I cannot confess something against you. Confession means of his own.
Yeah, he's saying over phone a confession to his mother, stating, now, my lord, if your page 8 shows about the death was due to asphyxia caused by strangulation along with throttling in nature. That is the post-mortem report. Now, page 10, my lord, that happens to be the deposition of the de facto complainant.
Yes.
De facto complainant. Now, my lord knows very well that FIR is used for corroboration and contradiction, my lord. Now, what does the deposition, whether the PW1 corroborates his statement or not? Let us see, my lord. Now, I have lost this case against the accused Shochindra Bormon, and the accused is present in court today. The incident regarding which I have come to depose in this court had happened on 27/4/2015 at about 7:30 p.m. Now, he says 27, the charge has been framed as per 28, the incident occurring, whatever. On the date of incident, at the relevant time, my sister Shobita was killed. My sister Shobita was married with the accused Shochin at about 13 years ago from today. After her marriage, she went to her matrimonial home and started her conjugal life with her husband. On the date of incident, my sister was at my house. And on that date, the accused called my sister on her mobile and asked her to visit a place near my house. So the accused called the sister on her mobile and asked her to visit a place near my house. Thereafter, my sister visited the place where the accused had called her. After 40 to 50 minutes later, the accused called my mother and informed her that he had killed Shobita and her dead body was with him. After getting the information on mobile, my mother immediately rushed to the place where the accused had told my mother that the body of my sister was lying there. I also accompanied my mother at the relevant time. I, with the help of my brother, brought the body of my sister Shobita at my house and subsequently took her to Nishiganj Hospital. After examination, doctor at Nishiganj Hospital declared my sister brought dead. Thereafter, the police sent the dead body of my sister to Mathabanga ST Hospital for postmortem examination. After this incident, I lost this case against the accused for killing my sister. This is the written complaint which was scribed by one Mohurar Aminur Islam as per my instruction. And after scribing the said written complaint, he read over and explained the content stated therein. And after understanding the content stated therein, I put my signature on the written complaint. The written complaint is marked as Exhibit 1 and the signature PW1 on the written complaint marked as Exhibit 1-1. So we see, my lord, he has corroborated his FIR and he says that the phone call came to his mother and whatever. So let us see the cross-examination, my lord. The distance between my house, which is in the village Kodalketi, and the house of the accused, which is in the village Unish Bisha, is about 5 to 6 kilometers. It is correct to say that my sister Shobita spent her matrimonial life with her husband at about 10 years prior to her death. As far as I know, the matrimonial life of my sister with her husband was good. It is correct to say that prior to her death, my sister had not complained anything against the accused. Out of her wedlock, my sister gave birth to 3 sons. The accused used to work for gain at Jaipur. Prior to her marriage with my sister, he used to visit home in between. Even after marriage of my sister with the accused used to visit Jaipur for his work. When the accused used to visit home, he used to visit my house along with my sister and the kids, and they used to stay for 2 to 3 days at my house. The relationship of the accused with my family was good. Prior to incident, the accused has visited my house with his kids and my sister, and they were residing at my house since last 7 days when the incident occurred. I am the only son of my parents. I was not present at my house when Shochin called my sister on her mobile and asked her to visit a place nearby my house. When my sister went out of my house, I did not see her. At the relevant time, Shochin had a mobile and one mobile phone at my house. My mother was also not there in the house as she had visited the nearby shop. My father was also not present in the house and he has visited to the local market. At the relevant time, the mobile phone was at my house. My mother received the phone call from the accused on her mobile, and at the relevant time, she was in the courtyard of the house. I did not hear the conversation on the mobile. My mother informed me what she heard on her mobile. By that time, my father had also returned home from the market. There is a banana grove behind my house, and the owner of that banana grove is my uncle. Adjacent south to my house, the house of Ashinath Burman is situated. Southwest of the banana grove, the house of my uncle is situated. In between my house and the house of my uncle, there are 5 to 6 houses situated, and the owners of those houses are Oshinath, Robi, Ramani Burman, Rajani Burman, Jagannath Burman, and others. When I reached at the place of the occurrence, the neighboring people also reached there. I shifted my sister to Nishigan Hospital in an Alto van, and I, along with my Pishi and one other person, was inside the vehicle. No voice was recorded in the mobile phone of the accused or my phone. Not a fact that the accused did not call my mother on a mobile phone, or the accused did not inform my mother on her mobile that the accused had killed my sister is false. Not a fact that the dead body of my sister was not kept with the accused is false. Not a fact that the accused did not consume poison out of his agony is false. Not a fact that the accused was not admitted at Nishiganj Hospital for consuming poison is false. It is correct to say that the local people assaulted the accused after the incident.
Did not read the entire thing you have said. The accused was also, accosted by the local people and all. He does
I
not
cannot
agree.
say what sort of injury the accused sustained.
That is beside the point. Yes.
So PW2, whether she has corroborated the statement of
PW2
the
is the mother.
mother. PW1 is my son who lodged complaint against Shochin Burman. He is present in the court. Shobita Burman is my daughter. She was married to Shochin Burman merely 12 to 13 years ago. Shobita is no more. incident took place 3 years ago
There's a
on
serious contradiction in her cross-examination. Serious contradiction.
17 March. She says the incident occurred on 17 March, my lord. That did not occur on 17 March. It occurred on 27th April. Now, it was evening time when my son was outside for playing purpose and my husband was outside for selling vegetables. And I went to nearby shop to purchase sugar. And at that time, my daughter Shobita Bormon and her husband Shochin Bormon were at home along with their 3 children. Now, this was not stated by PW1. He said the accused called the deceased over phone. She's saying at the time my daughter Shobita Bormon and her husband Shochin Bormon were at home along with 3 children. Now, why it has been said, I'll come later on, my lord. Subsequently, when my son got back, he did not notice Shobita and her husband and asked their children about them, to which the elder son stated that both of them were outside, and subsequently my son-in-law called me on my mobile and asked me to hand over the phone to my husband. And Sachin then narrated to his father-in-law that he murdered our daughter Sobita and left the body on the backside of the house in the banana garden. And my son took me there, but I was in tears. And when Sabita was taken to doctor, she was declared brought dead. And I was interrogated by the police and I narrated to police whatever I stated today. Now, my lord, she says subsequently when my son got back, he did not notice Sobita and asked her husband and asked their children about them, to which the elder son stated that both of them were outside. Whereas, my lord, this was never stated by the PW1. He have never spoken about the children being present in the house, madam. Now, and there's another big contradiction where the mother-in-law says that I've handed the phone to my husband and the Shoching told over phone to the husband. So the thing about
But the son was not there at that point of time when the phone call was received.
Yeah, when
Husband, the brother PW1 was not there. He said he was outside the home. So he said that 2 contradictions. One, that mother received the call when she was in the shop. Mother says when I returned home, then I received the call. Secondly, mother says I handed over. Husband heard the call, heard that confession so called. And PW1 says no, mother heard. But PW1, the brother was outside.
But the brother came in and said that the accused called her sister over phone and she went outside.
But
that
he was not present. He probably said somehow that he was not present at that point of time when the call came.
Now, he said that thereafter my
Probably he said that he was not present when the call came. Let's just check.
He was playing football, he returned back and thereafter.
On the date of incident, my sister was at house. And on that day, the accused called my sister on her mobile and asked her to visit a place near my house.
Yes.
That is his statement was, my lord.
He says in the middle of page 11, I was not present at my house when Sachin called my sister. And my mother was also not in the house. My father was also not present.
But this facts, my lord, is not stated in the FIR. That's very important, my lord.
FIR is not an encyclopedia.
My lord, but
you argue in every other case.
Material facts is required to be stated, my lord.
No, material fact was the murder, the death.
I'll show judgment. The main thing is that, my lord, the case was based on extrajudicial confession, my lord. The FIR starts by saying that the accused called the mother-in-law and stated that he killed, which was stated, corroborated by PW1. Now, PW2 says that I did not receive the, I got the
Husband
call.
Came. Husband, father came.
Now, should I read the cross-examination?
Yes.
My lord of PW2 cross-examination. I did not witness when my daughter left home, nor I witnessed when Sachin left home. I was outside home for about more than 1 hour. When I got back home, immediately I received telephone call from my son-in-law and Pankaj returned thereafter. I had no talk about death of my daughter. I heard about death of my daughter from my husband. One Mangalchand Burman, being my brother-in-law, is the owner of the banana garden situated on the backside of my kitchen. I and the eldest son of Sobita and Sachin rushed to the Kola Bagan first. Thereafter, local people came there hearing my shout. The mobile phone on which Sachin called was of mine. I cannot recollect the number. That phone is not in service now. Police did not seize that phone, nor I produced the same. Sachin used to visit outside Bengal for job purpose. Sachin used to live separately with his wife. Sachin came to our house with wife and children about 7 days prior to the incident. At that time, Sachin wanted to go to Jaipur with his daughter, with his wife. My daughter was willing, but we asked them to move after some time since we are arranging marriage of our elder son. Marriage date was not fixed till then. They were happy during stay at our house. Not falsely stated that Sachin called over my phone and asked me to hand over the phone to my husband, which there was not a fact. May I, my lord? Achha. Not falsely stated that the Sachin told to my husband that he murdered Sobita and left the body in the banana garden beside my house. I did not go to doctor or elsewhere except to banana garden. I have no idea whether Sachin consumed poison subsequently after death of Sobita. I have no idea whether Sachin was taken to Nishiganj BPHC and then referred to Kuch Bihar MGN hospital. Not a fact that Sachin did not commit murder of Sobita. Not a fact Sachin did not state he murdered Sobita and left the body in banana garden. Not a fact someone else was responsible for the death of Sobita. Not a fact that this case was falsely lodged against Sachin.
So they did not see him commit it.
The circumstantial evidence.
Apparently, he himself confessed over phone.
Phone. That is their claim.
Yes.
Yes, my lord.
And all of them admit that till the death, at least the relationship was very good.
Good. Yes, my lord. But that has not been corroborated by PW2 that she heard over phone Sachin telling
No,
that.
she says somebody else, husband.
Husband. Now,
Husband
this is a
says what?
PW3. Husband.
Let's see what the husband says.
Father-in-law. Yes, ma'am. PW1 is my son who lodged complaint against Sachin Bormon. He is present in the code identified. Shobita Bormon is my daughter. She was married to Sachin Bormon.
Husband says wife heard it.
Huh?
Husband says wife heard it and dropped the phone.
Yes.
Yes.
Should I read, my lord? Or
Read the relevant parts. Otherwise, we'll jump to the relevant.
Okay.
No, please.
My lord.
There's the relevant parts, Ms. Sarkar. You know what the relevant
my lord.
parts.
Yes, my lord.
Because we have it underlined by someone.
Acha. I asked the elder. Better I read it, but I did not.
Very good. In your own way.
Incident took place 3 years ago when Sachin murdered my daughter, Shobita Bormon, at the banana garden behind my house. At that time, nobody was at home. My son returned home after playing football and my wife went to the nearby shop to purchase sugar. And at that time, my daughter Shobita Bormon and her husband Sachin Bormon were at home along with their 3 children. He also says the same thing. Subsequently, when I returned home from market, the middle grandson stated to me, this is a new fact, the middle grandson stated to me that his father scolded the elder grandson. Then I asked the elder grandson about reason of scolding, to which he replied that when my father took my mother to the back of the house, I was trying to accompany mother, for which my father scolded me. Here comes the last scene. Then Sachin thereby, for which my father scolded me. Then Sachin thereby sound sign from back of the house. And I got angry and stated to him by saying, son of a spade, why he was scolding the children, since I am feeding them. Thereafter, I called Sachin to come in front of me, but he did not. Instead, give sound sing 3 times. Thereafter, my wife returned home and I narrated her the incident so far. Suddenly, call came on the mobile of my wife. And after hearing sometime, she dropped the phone. And after giving a shout, she rushed to the back of the house. The elder grandson also rushed towards the back of the house by saying that his parents are there. My daughter was lying there on the earth in the banana garden. When villagers came, Sabita was brought at home and we noticed mark of strangulation on her neck. Thereafter, Sabita was taken to Nishiganj BPHC, where the doctor declared her brought dead. Subsequently, my son lodged the complaint and I was interrogated. Please. T-cross now. I went to market after 4 p.m. I was at the market for 2.5 hours. When I got back, and my son Pankaj was also not there, I returned home at about 7 p.m. When my daughter and son-in-law were at home, they were happy. He also says so. Middle grandson is Povitro, and he was 5 years old at that time. Elder grandson is Joyinto Bormon, and at that time he was 10 years old. When Povitro was complaining me, Joyinto was studying book. When I heard from Povitro that Sachin assaulted Joyinto, I got angry. I did not call Sachin by taking his name, nor I called my daughter. Sachin also did not speak out, only gave sound sign, but I did not go back of the house. True that my wife dropped the phone after hearing few words. When my wife rushed, she shouted that our daughter was lying on the back of the house. Before reaching to the place where the body of my daughter was lying, local people rushed there. Before they reached, the local people was already there. Neither me nor my wife could see Sachin there at the back of the house. I did not visit hospital. I also did not go to the place. On 28th, police came to our house and interrogated me. True that when Sachin came with his family, he discloses that he wanted to go to Jaipur, taking his family, but my daughter was not willing to go to Jaipur. Not a fact, Sachin told me that when he left for outside, leaving his wife alone, people usually state otherwise for her, and for that reason, he wanted to take his wife with him to Jaipur. I did not notice where my daughter was taken after being found lying at the back of the house. I did not witness Sachin going to Banana Garden. Not falsely stated that when I got back home, my middle grandson complained that his father scolded my elder grandson. During interrogation, I stated to the police that when I called Sachin, he gave sound sign 3 times for back of the house. I also stated to the police that my wife received phone calls, and after hearing sometimes she dropped the phone and rushed towards the back of the house by saying that our daughter was lying dead. Not falsely stated that my middle grandson complained to me that his father scolded my elder grandson. And when I asked about reason, the elder grandson stated to me that since he was accompanying mother, when his father was taking her to the back of the house, he was scolded by his father. Not a fact my wife did not receive any phone call, nor she rushed to the back of the house. Not a fact that there was no mark of strangulation on the neck of my daughter. Not a fact my daughter was murdered by someone else. Not a fact we are pointing towards Sachin out of suspicion. Not a fact I'm deposing falsely. So my lord, the son says the mother heard over phone. The mother says the father-in-law heard over phone. The father-in-law says the mother heard over phone. So who heard? No one knows, my lord. And based on this extrajudicial confession, also the learned court has come to the conclusion that he has done the crime. Now, my lord, the deposition of PW4. And PW3 also for the first time brings into the thing, like the son saw the father going with the mother to the backside, and when he followed, the father scolded him. And that fact, the last thing together theory has tried to be brought only by PW3 from this stage onward. PW2 and PW1 doesn't speak anything about that. Now PW4, my lord. I know Pankaj Bormon, who lodged complaint against his brother-in-law, Sachin Bormon. He is present in the court. Incident took place 3 years ago in the evening. I heard the mother of the victim shouting, and when I, along with the villagers, rushed to her home and then to nearby Banana Garden, found that the lady was lying on the earth. Thereafter, the victim was taken to home. I have no idea about how and what happened, nor I can say anything more. He says,
PW3 probably said that villagers were already there.
Yes.
He says villagers went later. Heard the mother of the victim shouting and went along with villagers, rushed to her home and then to nearby Banana Garden, then found.
He did it. This person, Robinto.
This person says he was one of the villagers. He says after hearing the shout of the
I heard the mother of the victim
they
shouting.
went there. But somebody, either PW2 or 3 said
PW3.
3 said villagers were already
there. But there were many villagers, my lord. He's just a one of the villager.
No, he says, I heard the mother of the victim shouting, and when I, along with villagers, rushed to her home and then to nearby garden,
His
found
home
the
and thereafter to the Banana
anyway,
Garden.
yes, very good.
And found that the lady was lying on the earth. Thereafter, the victim was taken to home, and I have no idea about how and what happened. He doesn't have any idea. In spite of going to the house, where so much things were going on. I know Pankaj Burman, who lodged the complaint against his brother-in-law, Sachin Burman. He's present in the court, identified. Incident took place 3 years ago in the evening time. I heard sound of crying from the nearby house, and when I, along with villagers rushed there and then to the nearby banana garden and found that my niece Shobita Barman was lying on the earth. Thereafter, the victim was taken to home. I have no idea about how and what happened, nor I can say anything more. I was interrogated by police. My house is bit away from the house of Paresh Barman. Shobita is my niece, my para relation. I was in the house of Paresh for 5 to 7
We have
minutes.
seen up to PW5, he also came later.
Yes, and he doesn't hear anything about the incident, what has happened or whether the husband has killed the wife.
So hard hue and cry. And
Huh?
rush to banana.
Kichuhi boleni.
PW7 similar.
PW7.
7. Page 21.
Yes. 21. So PW6 also says the same thing, my lord. He also doesn't
Up to
know.
7, same.
Up to 7, same. 7 says that I heard the sister of Pankaj was murdered.
Same.
But in his cross, he says that my house is about 400 kilometers away. When I reached there was already 25 to 30 people. I did not witness any incident. I cannot name the person from whom I heard that the sister of Pankaj was murdered. And not a fact that I did not hear the sister of Pankaj was murdered. So here's the evidence. And thereafter, PW8 is a retired constable. And he takes the dead body to the SD hospital for PM examination. So PW9 is important, man.
Yes.
This is a child witness. May I, my lord? May I read?
Yes. Provided Dipong, he gives us permission. Yes.
I am a student of class 6 of Kodalkheti or Harchandra High School. Today, I have come to depose in this case. Thereafter, the court comes to conclusion. I tested the witness and he's able to give rational answers to my questions. And he's able to understand questions and able to give rational answers to my questions. And as such, he can be a competent witness.
The Shaka will start from here on the next
Yes.
day. Otherwise, the continuity will be lost.
Next day. Na, aajke.
Today, my learned brother has this anticipatory bail. Bails and all. So
Yes,
we
ma'am.
cannot disturb his bench.
My lord.
I'll be sitting idle after a few minutes. But my brother will not be. So his bench is heavy.
Yes, my lord.
Item number 19 will be heard next day in specially fixed matter.
Division bench will sit next day. So whatever is taken up on that day.
Milord, one intelligence, Milord, item number 41 in today's list, Milord. Matter has been pending since Monday. And Milord, there was a direction to submit special messenger post within 7 days. The time has been expired, Milord. So, Milord, I'm praying for extension of time, Milord.
Calcutta, we mentioned the Soma, we mentioned the Lepes, we mentioned it extended.
Yes, grateful.
My lord,
Order record
my lord,
part for
my
further
lord, in
hearing on
item-
June 15, 2020.
My lord, in
Yes.
item number 20, my lord, can I pray for a date, my lord? I am for the respondent husband, my lord. It is a FAT, my lord, appeal, my lord.
No particular date can be fixed. We have specially fixed matters on some dates, so no date. It will be taken up when it is called.
My lord, may I be permitted to mention? What court? আমি আগে বললে হতো
সোমবারই করুন
নোটিশ My lord, may I be permitted to mention one matter, Lordship?
Yes, what is the matter?
Lordship, this is a motion, Lordship, civil revision 1340 of 2026.
Please be a bit louder. Please be a bit louder.
Lordship, this is motion, Lordship. PO number 1340 of 2026, Lordship. The matter was heard initially before the principal bench by the Honorable Justice Om Naran Rai, and it was admitted and directed to serve the copy to the other side. But thereafter, at the time of signing, Lordship was pleased to observe that the matter is filed, should be filed before the circuit bench Jalpaiguri, and accordingly, after matter was came up under a heading to be mentioned, and 18th
Yes, you
matter
have to
was
hand over a
transferred
slip.
to
You have to hand over a slip. You are
Lordship,
there.
my junior
Very
is
well, it will
present
appear.
before
It will
the
appear. Yes, I have
Yes.
taken the slip. It will appear in the list.
Lordship, let it be appeared on Monday, Lordship, so that I can make arrangement for physical hearing, Lordship.
Yeah, whenever the file comes, it will appear. Yes.
It is come, Lordship. Today it has reached. I have taken information
Call karo.
from the circuit bench. It has reached.
The passover, one time passover. Yes, yes, we have heard. Yes. One passover. Next.
Item number 2.
Passover.
Item number 3.
Passover. 10 to passover kura bata.
Item number 4. Item number 5.
My lord, I am for the appellant.
Yes.
This second appeal, my lord, was earlier admitted by an order dated 6 July 2023. The substantial questions were framed. Now, my lord,
Yes.
today it came under the heading of application. My application, my lord, is under consideration by your
The
lordship.
application was not moved then. It was
Stay application was referred to the single bench for consideration.
Achha.
If you lord just glances through the order dated 6 July 2023 once.
Yes.
I am praying for accommodation for fixing on Monday.
Why, Mr. Mitruka? Why accommodation?
Your Lordship, on Monday I will come physically and will move before your Lordship.
You are for the respondent?
Yes, your Lordship.
On the prayer of the respondent, the matter is adjourned for the day. It will appear on Monday.
Oblige your Lordship.
Thank you. Now.
Item number 6.
I'm for the opposite party number 1.
देखिए दाओ डिफेक्ट देखिए पार्ट खुले रखो.
You are given the last opportunity to file the reply.
There is a defect. What is the defect? Let us check up.
Delay of 1110 days.
No, there were other defects also. Are they enjoying any interim order?
I don't have the knowledge retention.
By the order dated June 9, 2026, a last chance was given to the appellants to file their affidavit in reply. So it was also recorded that in the event no such reply is filed on the next returnable date within bracket today, bracket closed, no further chance would be granted to the appellants to file affidavit in reply. For sub next para, since none appears for the appellant at the time of call, appellants at the time of call, although the respondents are represented through respondent 1 is represented through counsel, the opportunity of filing affidavit in reply is closed and the matter will be heard on the basis of the application and the opposition. For sub next para, let the matter stand adjourned till June 16, 2026. For sub the appellants are directed to cure the defects as pointed out by the stamp reporter in the meantime. Tuesday. Please try to inform them so that they know that we have directed them to cure the defects. deficit could be and other things are there. Please ask them to check and cure the defects.
Item number 7. Page to the packet.
Lordship, I'm for the respondent.
7 Millard,
Central
I am-
Bank of India.
Millard, I am for
Yes.
the, Millard, I am for the Millard applicant.
Yes.
A recall application, Millard, is under consideration today. Millard, I'll just give a short background. of the
One
case.
second, what is the defect? CO তে আবার কবে থেকে defect?
Defect আছে নাকি আবার?
Oh, no, it is 6.
7. This
Oh,
is
7, sorry.
7.
Yes. Recall, yes, short background.
Yes. No, Millard, short background is, Millard, after a series of negotiations with the bank, Millard, the bank agreed to amount by way of an email for one-time
OTS,
settlement.
yes.
They were not offering the final letter sanctioning the OTS, but the communications were there on record. We filed a writ petition before this court, seeking upon a direction upon the bank to conclude the OTS. During pendency of the writ petition, the bank came up with a letter saying that the OTS has been terminated. Now challenging that letter, Millard, we preferred a suit. The crux of the plaint was that it was a concluded contract, and accordingly there was no occasion for the bank to resile since they have already accepted money pursuant to those negotiations simultaneously. The trial court rejected the ex parte ad interim injunction. Appellate court rejected the ex parte ad interim injunction. It came before your lordship. Your lordship considered this in an earlier bench. Your lordship held that the suit was prima facie maintainable and an injunction was granted, restraining the bank from dealing with the mortgage property and to give any further effect to that communication of termination. And your lordship was also pleased to remand it back before the learned trial court for contested hearing of the application. Contested hearing took place. The learned trial court sustained one component of that order, that is not to give effect to the letter of termination. But the other part, which your lordship granted, not to deal with the third party, not to deal with the mortgage property, that the trial court held that this won't be proper since this will interfere with the recovery process. Now against that, and Ms. Kapil has been preferred, that is pending adjudication for SIR and all that, that has not been taken up. Now, Millard, in the meantime, in the recovery proceeding, we had preferred an application stating that in terms of your lordship's order as well as the trial court's order, the termination letter has been kept in limbo. The effect is the OTS has revived. For the time being, at least the proposal or the prospect of the OTS has revived since the termination letter is being stayed. So at this juncture, there cannot be any occasion for the bank to move any further with the recovery process. That application was rejected by the recovery officer. Against that, in spite there being an appellate remedy on payment of a substantial amount, we preferred an application under section 227. At the first instance, a coordinate bench was pleased to admit the civil revisional application. The bank was present. The question on maintainability was considered. The court was of the view that even then 227 is maintainable. The application was entertained. On the last circuit bench, on the penultimate day, on Thursday, this matter was taken up by the Honorable Coordinate Bench. A prayer was made, Millard, by one of my junior that my father is extremely unwell. I got the news at 2 p.m. I had rushed to Alipurduar to attend him for a day. And at a day's accommodation was sought. And Millard, the Honorable Judge Millard, without considering that, on that date itself, Millard, dismissed the civil revisional application only on the ground of Millard maintainability, that there is an appellate remedy. Now, Millard, the question why the civil revision was actually entertained and what was the special circumstance for which Millard the recovery proceeding was sought to be stayed by at our instance, Millard, that was not at all considered by the Honorable Judge. Millard, I have annexed documents, Millard, showing the illness of my father, which was a very personal ground, documents showing that I actually traveled, the Millard, the toll plaza deduction, the everything.
Mr. Ghosh, that is not required, but here it's not a question of restoration. Restoration applications other benches can take. I think it should be heard by the learned judge who passed the order.
But Millard, the
Yes,
difficulty,
You have to mention it before the principal bench.
Millard, in that event, Millard,
I'll
since
record an order and
Millard,
so that facilitates.
till that time, Millard, let them lay their hands from taking any further step.
So
At
I
least
cannot
that
do
much
that.
of
I cannot do
Millard.
that because he cannot
Lo-
take up the
lo-
matter, he cannot pass that order.
Lordship,
Because in the
Lordship, the
meantime,
matter was
I'll hear you,
finally
Mr. Mishra.
decided
I'll
on
hear you,
May,
I'll
Lordship.
hear you. I will hear
After-
you.
No.
Please, Mr. Ishta, keep mum. I'll hear you, I'm telling you. Yes.
Millard, the moment this order has been passed, Millard, they have already taken out an order for appointment of a receiver. And Millard, the entire, letter and spirit of Millard, the injunction order goes in air if the recovery proceeding, Millard, goes any further.
Let us hear, Mr. Yes, Mr. Mishra, what you are saying?
Lordship, the final order dated 21st of May was passed by the coordinate bench of Honorable Justice Arindam Mukherjee.
Yes, yes, we have
The
seen.
the matter was, Lordship, heard at length twice. First by Honorable Justice Om Narayan Rai on 27th of April 2026.
That
and
is not
thereafter
judgment, but it
by
has
the
to be taken
Honorable
up by the
Justice-
appropriate. Mr. Ghosh, no interim
Absolutely,
order,
Lordship.
I'll just,
But at least the
Lordship, it has
status
to
quo.
it would
so
be
that
inappropriate, Mr. It would be inappropriate. Then for that
it has
also, I
to be
have to
moved
hear a
before the
prima facie case
same
and
court.
give a hearing. Since the present application has been filed for recall of an order dated May 21, 2025, passed by Arindam Mukherjee.
26, Millard. May 20.
Oh, sorry, but May 21, 2026, yes. Passed by Arindam Mukherjee, J, for the sake of judicial propriety, the matter should be heard by the same bench. Accordingly, let the matter go out of the list with liberty to the petitioners to mention the matter before the concerned learned single judge, if necessary, before the principal bench. You give a notice to them and then mention.
Yes, Millard, definitely.
Mr. Mishra, they'll
Deeply
give a
obliged,
notice to you and mention it before the principal. Thank you.
Deeply
Yes.
obliged, Lordship.
Obliged, only obliged, not on merits. If it was on merits, then deeply.
Yes,
Yes.
Lordship. Yes, Lordship. Thank you.
Thank you. Thank you. Yes.
Item number 8.
Pass over, second call.
8.
8, you are appearing? Oh. Can you put a pass over? Yes, Mr. Dutt. That evidence. This was that matter. Amendment to your ground was that not that matter.
No, the amendment of written statement.
You sought amendment of written statement by claiming that your knowledge came from the deposition.
No,
Not
no,
that
no,
matter.
no. That's another. Deposition is after.
But the same set of counsel. Probably. Oh, it's you. Yes. Sorry. Yes, Mr. Datta, just remind me once. Amendment to written statement was refused.
Was refused.
Why refused?
Refused on the ground of delay.
So what is your answer to that?
Actually, on the day of amendment, petition was filed, the evidence has not commenced. Before, it is pre-trial evidence.
What is the law on that?
Huh?
What is the law on that? After framing of issues or after?
No, as per.
Probably there are judgments saying that when issues are framed.
It is issue, and after issue there is a contradiction. In Supreme Court also.
Supreme Court last decision is probably issues.
No, thereafter, last decision from the issues, that was, but it was contradicted later.
By the Supreme Court?
No. Issue was there, and Baldev Singh was there. Baldev Singh, Justice Tarun Chatterjee was there. But thereafter, there are several judgments in Calcutta High Court and also in Bombay High Court. And later, it was referred to larger bench in the Calcutta High Court. And Calcutta High Court thereafter decided the same matter.
In your favor, I mean, not issue.
Not issue. That is, I am
Actual
giving.
hearing.
Huh? No, that is from the cross-examination, on the initiation of cross-examination.
Cross-examination or examination?
Cross-examination.
Hearing starts before that when you file your chief.
No, as per the larger bench of this Calcutta High Court, I am giving the judgment.
Please decide. Here, what was the stage? Evidence has not started.
Evidence not started.
But issues have been framed, obviously.
Issues have been framed.
Not a larger bench, a division bench.
Yes, it is referred. The matter is referred
Acha, on reference the
on
division?
reference.
Acha, yes. The division bench considered Supreme Court judgments?
Yes, all the judgments have been considered. And this has not been overruled till date.
How was that judgment dealt with? The Supreme Court judgment that issues is the framing of issues? But is that dealt with
Yes.
in this judgment? Please give a copy to your learned friend also.
No, yes.
AIS citation. AIN 2019 Calcutta 131.
131.
This judgment even ranked 1 in the hit list. That's really here.
From 36 onwards, I think.
You have to give him a copy also.
Yes.
I think that will be easier for him. Otherwise, I must say I was also not aware of this. So he's entitled to a copy at least. No, this does dictum of Kailash. Kailash is that case. No, where is that judgment dealt with? That is what I am saying.
Vidyabhai and Kailash. Kailash is the first issue stated. Thereafter, Baldev Singh. All this.
Yes, yes. Para 37.
I'm 19.
This itself is contradictory, Mr. Datta. In para 37, it says, in the light of Vidyabhai and etc., it is implicit that the commencement of trial for the relevant purpose is when the court applies its mind to assess the list after the first affidavit of evidence is filed. To repeat, such application of judicial mind is when the first witness proves his affidavit of evidence, or such witness seeks to prove a document for it to be tendered in evidence, or cross-examination of witness begins, which cross-examination cannot begin before the chief is filed. So for all practical purposes, proves his affidavit of evidence.
Yes.
But that has also not happened in your case. Only on that count, let us see the impugn order in your case.
In this case, evidence started.
No.
He cross-examined.
Before the impugn order was passed?
No.
Yes.
Huh?
Yes.
Kindly see the impugn order, my
Yes. I have the documents with me.
Kindly see the include order. Date 24/3/2025.
Yes.
Yes.
21st,
Kindly come to my supplementary affidavit.
Supplementary. Court does not even say so. Court only says prayer for incorporation at this stage of the suit where evidence has proceeded. Court says evidence has proceeded.
Yes. Court says so, but I have given supplementary affidavit.
You have given the affidavit in chief also.
Yes. Chief and the tender also, everything. Page number 14 of my supplementary affidavit.
This is PW1.
Yes. And page number 20, that has been tendered.
Hmm. 19th May 2025.
After order. Order is of March.
On 23.
March 2023. Yes. Long before. No. Order is of March 24, 2025.
Order is of?
Oh, your application is much prior.
Much prior.
Application is much prior. Even the order is prior to start the commencement of
commencement.
Yes. On merits, what is your otherwise? Let us see. Otherwise, it will be a futile exercise to remand. The suit is for eviction.
No, sir. Actually, my lord. Actually, suit for injunction.
No, let us see the. Let us move on merits also. Then I'll come back to you.
Okay.
Yes, Mr. Datto, original written statement.
Original written statement is in the.
You have in the supplementary affidavit.
Yes.
And what is the amendment you sought? Let us see
Amendment is page number 29 of my.
Year was already there. You want to incorporate the month, week rather.
Week. Third week.
that. 11 after line 37. Para 11, let us see. Line 37, where is it?
Page number 6. Operator supplementary written.
How does it read? The para 37, line 37?
Line 37,
What does it start with?
Line 37 start with time the local voice. At the material point of time, the local voice.
At the material, yes. So you want to incorporate this after the word area. Used to play other of that area.
Yes.
You want to now introduce to possession forcefully on 31st April 1962? And used to play football and other games.
62 is there in line 11.
But there are other was the first amendment is you were wanting to introduce third week of May between in and 1962. Oh, acha. There. Aforesaid decorator left in the third week. Yes, this is innocuous. Why shouldn't it be allowed? They have already given the year. They now want to introduce the third week of May.
Actually, Lordship, they have taken the plea of adverse possession.
That will be decided on merit.
That's another matter.
Have their defense dismissed in the turned down in the suit. But amendment is, we are very liberal, particularly written statement, we are more liberal.
Actually, Lordship, please come to my objection. Page 32.
32, yes. They have already claimed adverse possession.
Yes.
Already claimed adverse possession. Now they want to introduce the, not even the date, the third week of May.
Actually, case was filed in the year 2009, and they have after 14 years, they are trying to incorporate the date for getting the advantage of specific ruling.
Yes, but the evidence has not yet started.
It started.
No, it did not. They have annexed the affidavit of chief.
Actually, Lordship, examination chief was, it was rejected 24th March 2025. Thereafter, examination chief was tendered on 19th May 2025.
Yes, everything is 2025. They
Yes,
filed
yes.
the amendment application.
They started cross-examination. Thereafter, the revision option filed.
They filed the amendment application in 2023.
Yes.
That is the relevant date. The court is late in taking up the application. That's not their fault. The date of filing of the amendment application is important, not when the order is passed.
No.
They filed in 2023. Your evidence started. The evidence started in 2025. You are saying. So 2 years later.
Actually, after rejection of the application of amendment, evidence was started.
Then you are admitting that evidence started after the filing of the amendment application.
Yes. And then cross-examination started.
Probably what is going on here.
Cross-examination
The
was
proviso to Order 6 Rule 17 says that it cannot be, it has to be filed before the hearing. I mean, not later. If it's later, then there is a bar. Now, the last decision is that when the affidavit of chief is filed and proved, from then, after that, if it is filed, then they have to explain or it is barred. Not before that. They filed long before. And this is innocuous. They have already said that the local boys of the area used to play football.
Yes.
You are not the local boys of the area.
No, I am not the, I am the one of the.
One of the local
person,
boys.
One of the person there.
Achha.
Actually,
Lordship, in this.
No. We will allow this amendment.
Actually,
amendment court is very liberal. They have to prove their case in merits, on merits.
Actually, the date, there is no documentary evidence. By oral evidence, they have to prove.
What are you saying? In pleadings, there will be documented evidence.
No. Lordship, after 14 years, they are trying to input this date.
If after 14 years you could not start your evidence, then they are entitled to.
No, I failed to start the evidence as because in the meantime, one club.
There is no bar in filing their examination chief, in filing their amendment before this. And written statement courts are more liberal. Already the rudiments of the case is there in the written statement. Not that they're introducing a contradictory or a new case. There would be, maybe I would have considered a bar if it was contradictory, mutually exclusive with their original case. Then probably would have a good case. It's in support of their case. They are furnished for the particulars. Rudiments are already there.
Actually, Lordship, one club by order one ruled into petition that was allowed. They entered into
maybe, but they're entitled. I am allowing.
But thereafter, that was rejected by honorable court.
Maybe.
And thereafter, they again filed this amendment application.
Very good.
Lordship, please come to the page number 35, the order, impugn order.
I've seen the impugn order. Otherwise, how could I be commenting on this? Hard perused, appears sought to incorporate, prayer for incorporation of some dates at this stage where evidence has been proceeded. This is wrong. Evidence is proceeded on the date when the court takes up the matter, not when the application was filed, not even on that date. This is a wrong premise. The present revisional application has been filed.
Judgment I am citing, Lordship.
Cite it quickly, yes.
regarding order 6 rule 17
Yes.
2024 3 SCC 705, that this is one important factor to be seen at the time of consideration of any application for amendment
You
pleadings.
do your personal reading at home. Give me a copy so that I can also read. Which paragraph? Which paragraph?
First paragraph,
First paragraph.
but it is underlined.
It's underlined also. Acha, the head note, not the first paragraph.
It not para 8, 9, 10, 12, and 14.
In that case, it was done. It's on the facts of the case.
No, it wasn't in the judgment itself. It is fag end of trial. 3.5, page number 3, para 3.5.
Yes, yes. There also court said that no due diligence was pleaded. As if it was pleaded, then it could have been considered. No, sorry. The present revisional application has been preferred against an order whereby the defendant stroke petitioner's application for amendment of their written statement was refused by the learned trial judge. Whose sub next para learned counsel for the petitioners argues that although the amendment application was filed on May 6, 2023, much prior to the commencement of trial by proving the affidavit in chief filed by the plaintiffs, the learned trial judge proceeded to reject the amendment application on the premise that the incorporation of some dates in the written statement at this stage of the suit, double inverted, where the evidence has been proceeded, double inverted close, seems to hamper the rights of the plaintiff in the suit, and there is every possibility of change of nature and character of the suit and the defense taken initially. Next para, it is contended that the learned trial judge completely overlooked the fact that on the date when the amendment application was filed, the evidence had not yet started at all. Learned counsel places reliance on a division bench judgment of this court in the matter of such and such reported at AIR 2019 Cal 131 in support of the proposition that amendment that for the purpose of the proviso to order 6 rule 17 of the Code of Civil Procedure, the commencement of trial is when the court applies its mind to assess the LIS after the first affidavit of evidence is filed, and such application of the judicial mind is when the first witness proves his affidavit of evidence or such witness seeks to prove a document for it to be tendered in evidence, or the cross-examination of such witness begins, whichever is earlier. Next para, learned counsel further submits that the rudiments of the pleadings were already there in the original written statement, and only further particulars were sought to be furnished by way of amendment. Thus, there was no scope of alteration of the nature and character of the suit by the amendment. Next para, learned counsel appearing for the plaintiffs stroke opposite parties opposes the revisional application and submits that the amendment application has been taken out after long 14 years from the institution of the suit. It is contended that Due to pendency of interlocutory applications in the interregnum, comma, the evidence could not commence in the suit. Full stop. However, comma, it is further submitted that the case sought to be made out in the written statement in respect of alleged adverse possession of the premises by the defendants is not tenable otherwise in the eye of law. Full stop. Learned counsel for the plaintiff stroke opposite parties cites such and such reported at 2024 3 SCC 705 for the proposition that any right accrued to the opposite party cannot be taken away on account of delay in filing an amendment application. Full stop. Next para. Upon hearing learned counsel for the parties, comma, it transpires that that a division bench of this court, comma, in the matter of Sri Sri Ishwar Radha Bihari Jiu Supra, comma, upon taking into consideration all previous judgments holding the field, comma, came to the conclusion that for the purpose of the proviso to Order 6 Rule 17 of the Code of Civil Procedure, comma, the commencement of trial shall be construed to be when the first witness proves his affidavit of evidence or such witness seeks to prove a document for it to be tendered in evidence or the cross-examination of such witness begins, comma, whichever is earlier. Full stop. Next para. From the annexures to the supplementary affidavit filed today by the petitioners with the leave of the court, comma, it appears that the affidavit, the examination of chief on affidavit of the plaintiff's witness number 1 was tendered to the witness and proved for the first time on May 19, 2025. Whereas in the impugned order, comma, in the impugned order itself, comma, it is reflected that the amendment application was filed on May 6, 2023. Full stop. Next para. Thus, comma, following the dictum of Sri Sri Ishwar Radha Bihari Jiu Supra, comma, the amendment application was filed long prior to the commencement of trial and, comma, as such, comma, the rigors of the proviso to Order 6 Rule 17 of the Code are not attracted at all. Full stop. Next para. The learned trial judge, comma, instead of adverting to such aspect of the matter, comma, mechanically dismissed the amendment application not only on the ground of delay but also on the finding that such amendment, comma, if allowed, comma, has every possibility of change of nature and character of the suit and the defense taken initially. So next para. However, comma, such observation of the learned trial judge is patently perverse. Full stop. In the original written statement, comma, the premise of the defense, comma, inter alia, comma, was alleged adverse possession of the defendants. Full stop. Next para. In paragraph number 11 of the original written statement, comma, the defendants stroke petitioners had already stated that the recorded owners left in 1962 from Holdibari for East Pakistan, comma, now Bangladesh. Whereas by way of the proposed amendment, comma, between the word double inverted in and the year double inverted 1962 double inverted close, comma, the expression, the phrase within double inverted third number, numerical 3 RD, third week of May double inverted close is sought to be inserted. Full stop. Hence, comma, insofar as such component of the amendment is concerned, comma, the foundational fact of the pleading was already there and the year 1962 was also mentioned in the original written statement. Full stop. The petitioners merely sought to introduce, seek to introduce the specific week of the true owners allegedly leaving the suit property. So next para, by the second component of the amendment, comma, the defendant stroke petitioners seek to introduce the factum, the allegation that the local club, the boys of the local club of the area took possession forcibly on 31st day of April, 1962. Full-stop next para. In the original written statement, comma, it was already pleaded that at the material point of time, the local boys of the area used to play football and other games in the said lands, including the suit land, peacefully, comma, publicly, comma, openly, comma, continuously, comma, uninterruptedly, and adversely against the aforesaid real owners. Which of next para, thus, comma, nothing new, comma, changing the nature and character of the original defense has been sought to be introduced by way of the proposed amendment. Full stop. Hence, comma, particularly in view of the fact that the rigor of the proviso to Order 6 Rule 17 of the Code is not applicable, comma, there could not have been any bar in allowing the said amendment otherwise. For next para, it is well settled that merely allowing amendment in the pleadings does not tantamount to accepting the facts pleaded in such amendment, and the amended pleadings would be subject to being proved on evidence in the trial. Full stop. Next para, thus, comma, no conceivable prejudice could be caused to the plaintiff stroke opposite parties sufficient to dismiss the amendment application. Full stop. Next para, insofar as the judgment cited by the plaintiff's opposite parties is concerned, that is Basavaraj Supra, comma, the said judgment was delivered in the context of the petitioners in the amendment application therein not meeting the preconditions laid down in Order 6 Rule 17, comma, since no due diligence was pleaded. Full stop. The Honorable Supreme Court categorically observed in the said judgment itself that in the case in hand, double inverted মধ্যে এটা হবে, comma, the respondents therein had not even pleaded their case before the trial court in the application for amendment that due diligence was there at the time of filing of the suit in not seeking relief prayed for by way of amendment. Push up next para, that apart, comma, the Honorable Supreme Court flagged the fact that the amendment application was filed at the fag end of the trial. Pushed up. Next para, the Honorable Supreme Court also considered previous judgments of itself where it was held that amendment may be refused if it introduces a totally different, new and inconsistent case or challenges the fundamental character of the suit. Full stop. In the facts of the case, in the facts of the cited judgment, comma, the Honorable Supreme Court observed that by way of amendment, comma, relief of declaration of the compromise decree being null and void was sought, which would certainly change the nature of the suit, which may be impermissible. Full stop. Next para, it is trite law that a judgment is a precedent only for the contextual matrix in which the same is delivered and cannot be applied universally as precedent in all cases. Full stop. Next para, as discussed above, comma, since the facts of the cited report are entirely different from the present case, comma, where the amendment application has been filed before commencement of trial and does not change the nature and character of the suit, comma, the learned trial judge refused to exercise jurisdiction vested in him by law in dismissing the amendment application filed by the defendant stroke petitioners. Full stop. Accordingly, comma, CO number, this CO number 207 of 2025 is allowed on contest, comma, thereby setting aside the impugned order bearing order number 114 dated March 24, 2025, passed by the learned civil judge, bracket junior division at Mekliganj, district Kuch Bihar, in title suit number 03 of 2009, and allowing the application for amendment filed by the defendants stroke petitioners in the said suit. Full stop. The concerned department of the trial court shall carry out the necessary corrections in the original written statement accordingly within a fortnight from the date of communication of this order to the trial court. Full stop. Next para. In view of the long pendency of the matter, it is expected that the learned trial judge shall dispose of the suit as expeditiously as the business of the said court permits. প্রথমেই একটা করে দেবে, সাপ্লিমেন্টারি এফিডেভিট ফাইল টুডে বি কেপ্ট আন্ডার।
Supplementary has been filed yesterday.
ও আচ্ছা আচ্ছা, তাহলে দরকার নেই।
And in the order itself, it was written.
Really? Thank you. Next.
Number 9.
Item 9, Lordship, I'm appearing for the petitioner.
Yes.
Lordship, the petitioner is the wife. This civil
You have
division.
served properly on the other side?
Yes, your Lordship. On the husband, I've served on several occasions,
But left.
but it has been returned to us. After that, with leave from this honorable court, we have also effect service on the learned advocate who's appearing on behalf of the husband before the learned lower court.
আচ্ছা।
So the same was received by them, but still to this day, they have not
Well,
made their
well,
appearances. Lordship, this
Yes.
this application has been preferred for transfer for matrimonial suit, which was preferred by the husband and is currently pending before the learned court of Alipur in South 24 Parganas. Lordship, the petitioner has a minor child under her care, and she also has a
What is the age of the child?
age of the child is 6 to 7 years. He is currently in 3rd standard
Yes.
primary school. Your Lordship.
What else?
Lordship, the petitioner also has a aged and ailing mother under her care, who is a very ill and bedridden.
Mother?
So, mother. And the mother is a widow. Her father died. So there is no one else upon whom the petitioner can rely and leave her minor child and the mother for a certain period of time to attend the courts. Till to this day, the petitioner is being compelled to appear before the learned court on a day-to-day basis because this matter has been kept pending to this day. And there is no stay in being enjoyed by this petitioner, Your Lordship. And the petitioners and the respondents are not making
When the matter was admitted, copy directed, no stay was granted?
No stay was granted, Your Lordship.
Why the learned judge must not have been satisfied with your case?
Might have been.
When was it directed?
It was in 2025.
26. February 12. Anyway. So minor child, ailing mother,
And
what else? Financial difficulty?
financial
Usual grounds?
difficulty, of course, Your Lordship. The petitioner works as a unskilled Aya at the government hospital. So Your Lordship
As a
knows
what?
unskilled Aya.
Unskilled.
Unskilled Aya. She is not a government employee. She works on her personal basis. So Your Lordship knows the meager amounts they earn on a monthly basis, and she also has a minor child under her care as well as her daily expenses. The
So
medicine.
if you have to attend your job, how do you look after, who looks after your child then?
Lordship, for the child is a school-going child. So
During that period.
at that time the child is.
But
in
if you
school.
have to go travel to Alipur, you probably have to stay at least one night there.
Yes, Your Lordship. She's being unable to appear before the court on a daily basis because she is facing financial hardship. She has no one to look after the child as well as her mother, and there is no maintenance is being paid by the husband as well.
Despite service, none appears for the opposite party husband at the time of call. Full stop. Accordingly, the matter is taken up for hearing ex parte. Full stop. Next para. The petitioner wife seeks the transfer of a matrimonial suit filed by her husband, the opposite party, which is now pending in the 11th court of additional district judge at Alipur, district South 24 Parganas, to the court of the learned district judge at Jalpaiguri. For some next para, learned counsel for the petitioner argues that the petitioner has a minor child of about 7 years, comma, to look after whom the petitioner has to spend a substantial amount of time at home. Full stop. The petitioner, comma, it is submitted, also works temporarily as an unskilled AYAH, AYAH,
Yes, Your Lordship.
AYAH, in a government hospital in Jalpaiguri itself,
Yes, Your Lordship.
in Jalpaiguri, and has to juggle between looking after the child and the said temporary job. Full stop. Apart from that, comma, it is submitted that the petitioner's mother is aged and ailing. Full stop. Thus, comma, to look after the child and her mother, comma, the petitioner has to be around in Jalpaiguri at all times. Full stop. Next para. That moreover, comma, it is pointed out that the distance between the court of the additional district judge, distance between the Alipur judges court where the matter is now pending and the residence of the petitioner is approximately 645.7 kilometers, comma, in support of which an extract of the Google map is annexed to the petition. Full stop. Next para. Thus, comma, upon hearing learned, next para, thus, comma, learned hearing learned counsel for the petitioner, comma, and going through the averments in the application, it is evident that in the event the petitioner has to contest the suit at Alipur, comma, where the matter is submitted to be going on a day-to-day basis, comma, the petitioner will have to stay over at Alipur, comma, which would be impossible to her in view of the predicaments faced due to the petitioner having to look after her minor child, comma, ailing mother, as well as to earn her livelihood from her job as an unskilled AYAH in a government hospital at Jalpaiguri. Full stop. Next para. Even otherwise, comma, the petitioner's financial hardship in view of the nature of the job is well understandable. Full stop. Next para. In view of the above circumstances, comma, the court is of the opinion that the petitioner has made out a sound case for transfer of the suit to the Court of the Learned District Judge at Jalpaiguri. Full stop. Accordingly, CO number 216 of 2025 is allowed, comma, thereby directing matrimonial suit number 2840 of 2017 pending before the 11th Court of Learned Additional District and Sessions Judge at Alipur, comma, District South 24 Parganas to the Court of the Learned District Judge at Jalpaiguri. Full stop. Next para. Upon the records of the suit being transmitted to the Court of the District Judge at Jalpaiguri, comma, the Learned District Judge at Jalpaiguri will be at liberty either to take up the matter himself stroke herself or allocate it to some other Court of Additional District Judge having jurisdiction within the territorial jurisdiction of Jalpaiguri. Full stop. Next para. This order shall be communicated at the earliest by the office to both to the Court of the Additional District Judge at 11th Court at Alipur as well as the Court of the Learned District Judge at Jalpaiguri. Full stop. Both the said courts shall act on the server copy of this order coupled with a communication of the learned advocate for the petitioner for the purpose of compliance without insisting upon prior production of a certified copy of the same. Full stop. No rest cost.
Grateful, Your Lordship.
Unnecessary.
Extremely grateful.
Thank you. You can communicate a website copy immediately so that it will be on the server today itself.
Lordship. I will communicate them.
Next.
Number 10.
Lordship,
Yes,
Item
Mr.
number-
Mahashay, what is that?
item number 10, the case actually, Lordship,
This is that one.
this that matter.
The witness.
Witness. Lordship, on yesterday I have filed one supplementary affidavit. As per
Supplementary
Lordship
affidavit,
order, I have filed on not only the examination chief and cross, Lordship, I have filed some on the order and the petition filed by the plaintiff in course of that day, which he came to learn. Now, Lordship, the affidavit in chief kindly come to Lordship first. my supplementary.
I'll
evidence.
just look into the impugned order once before.
Course, yes, Lordship.
Just to remind me.
Certainly. Refusal of amendment.
No, you filed the amendment in this case after the commencement of
Commencement
trial.
of trial.
Hmm.
Trial is my case is the trial where as soon as I am cross-examined the DW1, then I come to learn this share of the defendant, one of the defendants transferred to another. That has been come to know. This in short compass.
And what have you sought to introduce by the amendment?
That the deed number to whom he transferred.
And this is a suit for?
Suit for partition, Lordship. That's why the share actually changed.
You are the defendant.
I am the plaintiff.
Oh,
I'm the
you.
plaintiff at DW. I am the prosecution. Now, Lordship, what is the amendment that has been 75, page number 75 of my petition? There is a proposed amendment. Just I try to incorporate it, Lordship. Para 13 in by way of para 13. This in the year 1992. Defendant number 7, Revati Mohan Mondol, such as gifted 32 decimal land in favor of his sister, namely Proceeding Bishar. This is
They are all parties to the suit. No?
parties to the suit. No, Revati is not party to it, but yeah, yeah, 32 in his sister, namely Proceeding is not party to the suit. Revati is the party to the suit.
Defendant 7 Revati.
Yes.
So you wanted to say that Revati has given her share. So
Given her share. And thereafter, the Revati further transferred to her son, and that has been Dilip. He is in party of the suit. These two amendments short for come to the plaintiff of the plaintiff's case. That's the way of amendment.
the court held that the DW1 began leading evidence long back.
Lordship,
DW1,
I've been annexed my DW, Lordship. That has been my supplementary evidence. Kindly come to the DW was filed on 14th
January
14th January 2025.
and you filed your written this amendment?
DW, I came to learn DW on 17th May 2025. And as soon as I came to learn, I filed the 30th June 2025.
So why did you wait for 5 months after the DW being filed?
No, DW, first DW is DW1 filed this 14th first 2025.
And you filed in June 25.
Tendered this, that's why I'm giving the tender was given on 14th January 2025.
Yes.
And then deferred.
Same
Kindly
day.
come to the deferred on the plane of plaintiff.
Deferred is different. Whenever they file the affidavit in chief, prove it, your knowledge begins from there.
No, Lordship, and that's why I come to the my affidavit, their affidavit. DW never stated that they have been transferred the property.
But your case is that you learned from their
Yes,
deposition.
when I cross-examine, that is come
Where is
to-
that cross-examination?
Lordship, now cross-examination, my lord, the cross-examination start from the, I have filed all the certified copy. So there is no page mark, Lordship. Kindly cross-examination,
Commences, I'm seeing that order.
also commences from 14th January 2025. Just
Same
the
date.
tender has been given.
Same date.
Now, Lordship,
Where do they
DW,
state that? No, further examination is in chief is there, yes.
yes, 7th February 2025.
But then also they don't state.
No, they never stated that.
So
point.
where is your cross-examination from where it is revealed?
Lordship, now I'm to the Lordship, the third page. I am deposing on behalf of defendant number 6 to 9. Got it, Lordship?
Yes.
And suddenly, and last part, me and my brother, each of them 32 decimal of land. And in say, Proceeding Bishar is my younger sister and who is no longer more. In this case, when this question was raised, also uttered that he transferred the property, Proceeding
Not recorded here. Where is it recorded?
that has been coming to the my petition, Lordship. That is next petition. My petition comes, that has been petition. Lordship, the petition is, that is been said that during cross-examination of DW, the plaintiff came to learn that defendant number 7 has transferred his share in favor of one Proceeding Bishar and exhausted his share totally from the suit property. Further said, Proceeding transferred when the share in favor of the Dilip Chandra. On the same date, this petition was filed.
But that's not recorded here.
Because of when the matter has come on the mouth of the DW, it was objected because of I have no pleading. in respect of that point of time. That's why I come to the amendment. Because of, as soon as I on cross-examination of Prosha transferred the property, that will now come to kindly come to the my lordship, para number 3 of the affidavit in chief. Kindly come to the para number 3 of affidavit in chief, page number 2, internal page number 2. Affidavit in chief. This has been DW, say DW Ganapati. Got it, lordship?
No, after this,
No, this is my after supplementary affidavit, I filed the affidavit in chief of the DW. Whom I
examination chief filed by witness of defendant, oh, yes.
yes.
Ganapati, yes.
Yes, the Reboti Mohan Mondal, that has been strike out, lordship. And you see the Reboti Mohan strike out.
Ganapati struck out and Reboti written.
No, Reboti
Was
Mohan,
at the top.
Reboti is strike out.
And
Ganapati.
Ganapati written.
Now Ganapati stated in para number 2, para number 3. I say and affirm that myself and my brother, that is defendant number 6 and 7, jointly have become owner of the and co-sharer of the RRS plot number such and such, Moja such and such land, measuring 64 decimal within specific boundaries situated in the north of NH 31, followed by registered deed of rectification, deed number such and such, including map with the so purchase on being the region. In spite of that, on that, he never stated that the brother of this DW has transferred the property.
You have now sought to introduce an amendment by which you want to bring in that Reboti transferred her share to someone.
Reboti, yeah.
So you say that you have learned from the cross-examination.
Cross-examination, at the time of cross-examination, the DW spilled out. Yes.
Then it would be recorded. You did not ask for.
Not recorded because
no.
of.
You should have asked for. Did you file the application on the same day?
Yes, on the same day. Lordship, that is 17th Feb.
Did you ask for rectification of that recording of the evidence?
Yes, 17 I have.
You asked sought for an adjournment.
Adjournment, yes. Kindly come to my petition, Lordship. Those facts need to be inserted in the plain. That is what I have stated. Those facts inserted.
But you say here in this application that during cross-examination of DW, the plaintiff came to learn. You don't say that the plaintiff says, came to learn that defendant number 7 has transferred his share in favor of one Prosadirani Vishwas and exhausted his share totally from the suit property.
Yes.
Further said Prosadirani transferred her share in favor of one Dilip Chandra Vishwas. From their cross-examination of that date, I don't find these statements.
No cross-examination. Last part in the Lordship, Prosadirani Vishwas is the sister of the DW, this DW. And he, as soon as I come to that, Prosadirani is no more. He stated the further voluntarily she transferred the share, but that was not been come out to the DW because of this is not my pleadings. That's why
whatever is stated by the witness has to go into evidence. But with your objection.
No, more,
with your objection. Court will decide that
DW objection. Because of the DW never objected that point of time at learned advocate that your pleadings had not stated this point when you are crossing them.
Something, if it is not recorded in the evidence,
Lordship,
then how do you know that it was actually told by them? That is not a part of record.
No, that has been not been important, but I am to come into the same facts from that has been I have been stated in my petition. And if the transfer has not been made, Lordship, they have been suppressed that facts. If they have suppressed the facts, how that I am no.
I don't find anything in their cross-examination to indicate that this transfer was effected. Now,
no, Lordship.
So therefore, your case that you learned for the first time from their cross-examination about this is belied. It's gone.
No.
In their cross-examination, there is nothing of that sort.
Cross-examination at the last part of the cross-examination that has been deferred. Lordship, can you see the on my pair that has been deferred? Yes, cross-examination not been completed because of as soon as I come to learn, and there's a
how do you come to learn? It's not there in the evidence.
No.
You are saying from the bar that yes, it happened that on that date they had stated these things. But if it is not recorded in their evidence,
But because of that is not been recorded, because of there is no my.
that
pleadings,
is your statement. That
Lordship.
is not even stated in your application, contemporaneous application. It's not even stated here, but that was not recorded because it was of
The
not.
land, sir, my lord, this has been land, come to the land. That is further.
You say that it's your unilateral statement. It's not seen from their deposition. You don't say in your application even that please correct. This was actually stated by them. Or you don't say that it was stated by them, but it did not go into evidence because it is beyond the pleadings.
Yes, as soon as the lordship.
You have not stated that.
No, because of they
No.
inserted, because of the lordship, kindly come to those facts needs to be
From
inserted.
this, it appears that you wanted to prepare a ground for your amendment application.
That is on that point of lordship, because of I come to learn. Now, lordship.
Ramosha, let us be very clear. You
Lordship.
state in your application that during cross-examination, they state this, for which I required to amend my pleading.
Lordship.
That this is not recorded in their cross-examination.
Lordship. In
your application
I'm
of that
agreed.
date, you do not state that they had stated, but it was not recorded because of this reason. You have said that from their cross-examination, I learned this. But from their cross-examination, it's not there.
But I am agreeable on that point, lordship, because of that is not been come to the.
That is
recorded.
something which is coming now from you.
Now,
That
lordship.
is nowhere there. You are arguing for the first time. It's not in your application.
But lordship, so far the my.
It's not even there in your amendment application. In your
Yes.
amendment application also you say the same thing.
No,
That they
transfer-
learned from their cross-examination.
No, lordship, my amendment in para number 4, lordship. Can you come to
Achha.
this para page number P274.
Read that portion.
They also come to learn by the plaintiffs that before publication of some portion
This
of the
much,
land
nothing
has been
else.
transferred.
Come
Each
to
by-
learn.
Each by defendant which facts did not mention earlier at the time of filing the suit. That is
Come
been-
to learn when, how, not
Lordship,
stated.
that has been incorporated, lordship.
Nothing stated. Nothing stated.
Lordship,
In
because of,
this matter, the previous, in the judgment cited by your learned friend in the previous matter applies.
yes, no, lordship, because of the trial has been complete, they have been suppressed. That they have been, at least they have to disclose that fact. If they disclose the fact, I can be incorporated. This incorporation cannot come into the fair, lordship.
Sir, I am also in your application,
Lordship.
proviso debars any amendment after this
Agreed.
commencement of trial.
Agreed. I am agreed.
Provided there is only one relaxation that you disclose, you show sufficient reason, due diligence, why it could not be filed earlier. For that, you have shown a reason which is not borne out by the records. You have not shown any reason in the application. In the amendment application, you now post facto in revision, you are placing these things. But in the amendment, what did you say? In the amendment application, you said only came to learn.
Came to
No
learn.
explanation.
Sir, my lord,
This
they
was
came-
rightly rejected.
that information from this petition also been disclosed. That at that time of cross-examination, it is come to learn.
No.
And lordship,
No,
kindly-
cross-examination does not say anything of
no
that.
cross-examination that has not been called because of if the pleading has not been stated, how can I cross-examine that? That has been by objected.
You
That's
are saying
how I was
this for the
absolutely-
first time, you said, I am Osha. What you are saying now, that they stated this, but it did not go into evidence, that is not borne out either by this same date application, nor in your amendment application. In your amendment application, there is not a single line of explanation as to the delay. We came to learn later.
Lordship, now the lordship can
Right.
come to the petition. That the petition I have been filed, that has been clearly shows that at the time of cross-examination, it is learned from the mouth. That is the defendant Namasoba has transferred the land. While during cross-examination of the plaintiff came to learn.
But the cross-examination is before me, it's
The
not. showing there.
cross-examination, the lordship, that has been not recorded, but
Sir,
cross-examination.
I'm Osha, you are saying this, but if your client, who prevents your client, whenever you came to know later, very well, or you knew earlier, you omitted this in your written statement. They were cross-examined on a particular date. You took the chance and took out this application and say that, yes, from the cross-examination, I learned this to justify your amendment application.
Lordship,
Who prevented you from doing? Because I don't find in the cross-examination even a single sentence regarding this.
Lordship, so far my
Just to create a ground for your amendment application, your client cited their cross-examination. But their cross-examination does not reveal anything of that sort. Sorry.
Lordship, now.
That's
Lordship,
why I wanted to see the cross-examination, lightly pointed out by Lord.
Yes, yes, I have, that's why I have given, Lordship,
This
I-
application
all
does
the
not
papers I have submitted.
No, you have not suppressed anything. I'm
No,
not
Lordship,
saying that.
nothing.
But your client cannot get the
No,
benefit
Lordship,
of this.
if the defendant is when filed his affidavit in chief, that has not been disclosed. So now, Lordship, the share has been, if the share has been divided, that will be come to the who transferred the property in favor, and after whom he transferred, he also got the share. So because of the
yes,
affidavit in chief, neither in their WS or neither in the nor in affidavit in chief never stated that yes, my brother has transferred the property. Rather, he said that we are the joint owner of the 64 decimal land. So as per their statement, this is 64 decimal land. He, the brother and his brother will get, and thereafter again Dilip will go to get to 34 decimal land. That the land will be increased. If the
that is not stated in their cross-examination.
no, because of if the Lordship, I am not been come to the that point of the because of this amendment is not allowed, then it and subsequent stage has not been cross-examined because of the absence of pleadings, Lordship. Now, the defendant himself is a fairness. He is not fair in the inside. That is not been stated in the affidavit in chief. Further, this is my prayer,
We are
Lordship.
not on their fairness. I understand what you are
Yes.
saying, but you have to show something. At least a line, at least a sentence ought to have been devoted in your amendment application. Otherwise, we cannot bypass this proviso. In the amendment application, some reason had to be given. What you were saying, if that was stated in your amendment application, there would not be any problem. That at the time of cross-examination, this much. They said this, not recorded because it was beyond pleadings, which necessitated the amendment. What do you say in your amendment application? Learned later. Finished. Nothing else.
Lordship, that has been and also petition and the already been clarified that during cross-examination is learned. This is during cross-examination. Lordship.
You in your petition, Mr. Mohashay, I'm telling you for the 7th time. In your
Yes.
petition also, it's stated that it's not stated that they made this statement, but it was not recorded because it was not in the pleadings. That had to be stated in your petition.
That is not.
What do you state in your petition? That I've learned from their cross-examination given today.
Lordship.
I see the cross-examination, it's not there. So this is a wrong statement. This is an incorrect statement that you learned from their cross-examination. It's not there in the cross-examination is not whatever the witness feels in court. The witness comes in the courtroom and asks his advocate, how are you? That does not go into cross-examination.
No.
Cross-examination is what is recorded by the court as cross-examination. Only that, nothing further.
Lordship.
Cross-examination does not contain a single whisper of what you are saying, but you state in your application of that date that I have learned from their cross-examination. So you're obviously using their date of their cross-examination as a ploy to file a belated written statement. Even if you did that, I could have understood. In that application, you should have stated. You say I learned from their cross-examination, which is obviously a wrong statement. It is not there in the cross-examination. How could you learn?
Only during, sir, during cross-examination, not the mouth. From
Then how you learned is not explained at all. During their cross-examination, you learned how a bird flew by and dropped this letter on your lap.
So far, Lordship, the honesty says that in the doc, when some question has been arised in the doc and the witnesses, that has if
You should have stated that in your application.
that is
Or amendment application. Amendment application contains nothing.
amendment.
Why should you look into these?
Lordship, the amendment, Lordship, amendment petition and then the petition filed by the 17th May. That is taken together because of this is learned from the.
Even if you take together, it is not evident.
Lordship, Lordship, all they are the examination in chief. That is been not been
First
stated.
of all, it cannot be taken together. It has to be in the amendment application itself.
Lordship, yes, I do apologize on that point, Lordship, but this land, what is within land, that is been found from the, because of they then whispered anymore.
No, sir, I have heard you say.
No. Lordship, then it will be come into the, should will be, the increase the land will be increased. In the that is in
The plaintiff stroke petitioners have preferred the instant revisional application against an order whereby the application filed by the plaintiff stroke petitioners after the commencement of trial in a partition suit was dismissed. Full stop. Next para, learned counsel for the petitioners argues that the petitioners came to know about the facts sought to be incorporated by way of amendment from the cross-examination of the defendant's witness. Full stop. Learned counsel relies on a certified copy of the said cross-examination as well as a contemporaneous petition dated May 17, 2025, filed on the very date of such cross-examination to argue that in such application, it was categorically stated that during cross-examination of DW1, the plaintiff came to learn about the facts sought to be incorporated. That is, the defendant number 7 has transferred his share in favor of one Prasadi Rani Vishwas and exhausted his share totally from the suit property. For sub next para, learned counsel takes the court through the said application as well as the certified copy of the cross-examination. So next para, learned counsel for the defendants opposite parties controverts such submissions and argues that a belated amendment at the stage of post commencement of trial, at the stage of post commencement of trial, even if to be allowed, has to contain sufficient reasons for the delay and has to satisfy the conscience of the court as to due diligence of the party seeking to amend. In the present case, it is argued that no such explanation is furnished in the application for amendment. For the next para, a perusal of the amendment in question, amendment application in question shows that the plaintiff stroke petitioners, casually, merely stated in paragraph number 4 of the amendment application, of the said application, that they came to learn of the facts sought to be incorporated. Full stop. In paragraph number 3 of the said application, it is also stated that the new facts are necessary for the purpose of determining the real question in controversy between the parties and for proper redressal of the suit. Full stop. Next para. However, not a single sentence has been devoted to the exact reason as to why and how the the plaintiffs could not introduce such pleading at the inception and stroke out as to how they came to learn about such new facts. For sub next para, within the four corners of the cross-examination of the DW1, there is no whisper of the suit property or the share of defendant number 7 having been transferred to any third party. Full stop. Next para. In the application of event date, the plaintiff stroke petitioners merely stated that during cross-examination of DW1, the plaintiffs came to learn that defendant number 7 has transferred his share in favor of Prasadi Rani Vishwas and exhausted his share totally from the suit property, and that Prasadi Rani transferred her share in favor of one Dilip Chandra Vishwas. Full stop. Next para. Learned counsel for the petitioner for the first time before this court, submits that although such statements were actually made by DW1 during her cross-examination, those were not recorded in her cross-examination by the court since they were beyond the pleadings of the parties. Full stop. It is also submitted by the petitioners that for the said purpose only, the pleadings are required to be incorporated in the plaint in order to permit evidence to be adduced thereon, which would drastically change the shares of the parties. Full stop. Next para. However, neither in the amendment application, which does not contain any explanation whatsoever for the delay, comma, nor in the application for adjournment dated May 17, 2025, is there any mention of the purported turn of events that despite the statements in question being made by the DW1, those were not incorporated in his written in his cross-examination, since those were beyond the pleadings. Full stop. In the application dated May 17, 2025, it is merely stated that during cross-examination of DW1, comma, the plaintiffs came to learn of the said facts, comma, which is not borne out, comma, however, comma, by the cross-examination itself. Full stop. Thus, comma, the argument of the petitioners at this stage for the first time regarding such statements having actually been made and having been the source of knowledge of the plaintiffs cannot be is not credible. Full stop. Next para, the language of the proviso to order 6 rule 17 of the Code of Civil Procedure is couched in a negative manner, thus precluding any amendment to be allowed after the trial has commenced, with the specific exception that the court has to come to the conclusion, comma, for allowing such amendment, comma, that in spite of due diligence, comma, the party could not have raised the matter before the commencement of trial. Full stop. Next para, in the present case, comma, the said condition has not been fulfilled by the plaintiff stroke petitioners, and as such, the learned trial judge rightly rejected the amendment. Full stop. Next para, although the petitioners might have a point in arguing that if the amendments are otherwise necessary for the purpose of determining the real questions in controversy between the parties, comma, those may be permitted to be introduced even if due diligence is not pleaded, semicolon. However, comma, such argument would be germane in the event only if the application for amendment was filed prior to the commencement of trial. Full stop. Next para, after the proviso to order 6 rule 17 being incorporated by the 2002 amendment of the Code of Civil Procedure, comma, there is no scope of making such arguments if the amendment application is filed post commencement of trial. Full stop. Next para, accordingly, this court does not find any merit in the revisional application. Yes, what are you saying?
Lordship, one of the.
No, not after argument.
Lordship,
No, no,
kindly.
Sorry, no. Accordingly, CO number 220 of 2025 is dismissed on contest without any order as to cost, thereby affirming the impugned order bearing order number 57 dated November 7, 2025, passed by the learned Civil Judge Senior Division Sodor Court at Jalpaiguri, entitled suit number 68 of 2017. Urgency.
Apply.
Next. Pass for good.
Pass over matter item number 1.
Next.
Apply.
By the order dated June 11, 2026, comma, it was recorded that that was the second occasion, that was the second occasion when none appeared for the petitioner at the time of call. So accordingly, a last chance was given to the petitioner to move the matter, and the matter was adjourned for the day. So next para, today, comma, even on the second call, comma, none appears to move the revisional application. Full stop. Accordingly, CO 48 of 2026 is dismissed for default without any order as to cost. It is first for the first semester. Yes, it will.
Item number 2.
Yes, Mr. Datta.
My lord, in the last occasion, we have said that substitution is required.
Oh, yes.
I have, the CAN application is there, but it is not filed. It is ready.
So when should I take it up? Tuesday?
Tuesday.
On the prayer of the petitioner, the matter is adjourned till June 16, 2026.
Item number 3.
Lordship, I am for the petition. For the respondent one, my lord.
Right. All respondents have been served, or one is only
Yes.
then? Justice Arindam Banerjee has not yet become a judge of this.
Arindam Mukherjee, Lordship. Lordship.
Yes.
Lordship, this is my application under section 24(1)(b) of the CPC.
You want a clubbing of the two?
Lordship.
You want a clubbing of two applications?
Yes, clubbing or withdraw, dismiss this, withdraw the case pending before the Jalpaiguri district.
Withdrawing and doing what with the case?
Lordship,
Withdrawing and forgetting it?
no, Lordship, on the same cause of
Withdrawing, after withdrawing, what do you intend the court to do?
Lordship, there is a
Hear it itself or send it to the other court or what?
Lordship, there is two application filed. One is before the district judge Jalpaiguri and another is Coachbihar, Lordship. The case, Lordship, background of the case is that the present petitioner suffered an accident in Shitai, Lordship, that is come under the Coachbihar, Lordship, and he suffered multiple injury in his body. Subsequently, he filed a claim application under motor accident claim cases before the Jalpaiguri.
Accident occurred where?
Shitai.
Shitai is in Jalpaiguri?
No, Coachbihar. Subsequently, he filed another application before the Coachbihar. So we want to proceed with the case pending before the Coachbihar, Lordship, and
file an application under Order 23, Rule 1, and seek a withdrawal with liberty to proceed with the other one. There is a question of transfer of this. Both are for the same same cause of action.
Lordship,
or just not press this with liberty to move that.
Lordship, section 24(1), section 24(1)(b), Lordship.
Yes, 1B, what does it say? That is the power of withdrawal, the
Yes,
power
sir.
of transfer.
Yes.
Withdraw, try or dispose of the same, or transfer the same for trial or withdrawal to any other court, or retransfer same for the same court.
Yes, Lordship. So
That is the power of transfer.
not only power and withdrawal also.
Withdrawal, after withdrawal to hear itself, all transfer applications, we direct it to be transferred directly, but the implicit power is of withdrawal only.
Yes,
The
Lordship.
section says we withdraw it and then either transfer it to some other court
Yes.
or hear it ourselves
Yes.
or relegate it back to the court from where we withdrew.
Yes,
Section 24(1)(b) is that.
Yes, Lordship.
That is the power of withdrawal. But where is the reason for withdrawal in your case?
Lordship, reason is that
Same cause of action, you have filed two applications in two places. How
Yes.
can both proceed?
yes, Lordship. Lordship,
Section 10 bar, absolutely yes. Section
Lordship,
10 bar is
reason
there and
that he,
you have
Lordship.
forum shopping.
no, Lordship, may I submit, Lordship?
Withdraw and then do what?
I want
Be
to
aware
proceed
of the
with
law, please.
with the case pending before the Coachbihar.
Withdraw and then do what?
Lordship-
Withdraw means I withdraw it, keep it to myself.
No, Lordship.
Withdraw and then do what?
Lordship, similar.
You're entirely misconceived on the law. Entirely misconceived. I must say.
Lordship, similar case has been came before this court.
The previous court is also misconceived then if it did the same thing. To withdraw the suit,
Yes.
giving you leave to withdraw the suit. Have you got another copy of this?
Yes, I have.
Read it.
In this application under section 24 of the Code of
Read it into the microphone.
And this is an application under section 24 of the Code of Civil Procedure. The petitioner are the claimants in the MSCC such and such.
No, read from the third paragraph. The petitioners are pursuing.
The petitioner are praying for the claim case pending before the learned tribunal at Jalpaiguri to transfer before the learned tribunal at Coachbihar, where the other claim case is pending for analogous hearing and dispose of both the cases. Pursuing.
No, read properly. The petitioners are pursuing another claim case before another court.
Yes.
Petitioners are praying that the claim case pending before tribunal at Jalpaiguri be transferred before tribunal at Coachbihar, where the other claim case is pending for analogous hearing and disposal of both the cases.
Yes, Lord.
Pursuing same claim before two separate forums is unnecessary.
Yes.
Therefore, instead of transferring the claim case pending before learned tribunal at Jalpaiguri, liberty is given to the petitioners to withdraw the same. The petitioner was given liberty to withdraw your second case. and to pursue the claim case pending in the other court.
Pending before the.
Now do you
tribunal-
understand? Petitioner were given the liberty to withdraw their second case. You go and withdraw your case. That is what I am telling you. Withdraw it with, I am adding, with liberty to proceed with the other case.
Lordship, by this
This
directional.
revisional this
Lordship.
application for this application, comma purportedly under
Lordship,
section
one thing
24
May I add, Lordship?
is utterly misconceived.
Lordship,
Who, sir?
may I-
Learned
one
counsel
add-
for the petitioner submits
Lordship,
that
one thing, Lordship, may I, Lordship? Lordship, he suffered injury. He is from Shitai. Kojbihar district court is near from his home, Lordship, only 40 kilometer. And this Jalpaiguri district court is 120 kilometer. So he's completely, it's difficult for him to came and conduct the case here.
He
Lordship.
filed the suit.
And as per the act, Lordship, the district judge Kojbihar is the appropriate authority. So Lordship,
you have already filed a case before the Kojbihar.
yes, Lordship. So
No, as per the law, Jalpaiguri is the.
Kojbihar,
So you have filed a case there. Go and proceed with it.
yes, I have filed.
Don't press your application in Jalpaiguri.
Yes, I want to withdraw the case before the Jalpaiguri.
Go and do it. Who prevents you? Who is preventing you? Why did you file a 24 application here? যেটা বলেছিলাম সেটা থাকবে utterly misconceived. Fullstop. Learned counsel for the petitioner submits that the petitioner, comma, the victim of an accident, comma, has filed 2 claim cases for the self-same cause of action, comma, one at Kojbihar and the other at Jalpaiguri. Fullstop. The petitioner seeks a transfer of the Jalpaiguri case to Kojbihar. Fullstop. Next para. Learned counsel for the petitioner even cites an unreported judgment of a coordinate bench in CO 167 of 2025 within brackets Srimati Bharati De, DEY and others versus Kundan Prasad Jaiswal and others, bracket close, in support of his contention. Fullstop. Next para. However, comma, a bare perusal of the said judgment indicates that the coordinate bench, comma, quite correctly in my humble opinion, comma, observed that pursuing self-same claim before 2 separate forums is unnecessary, and therefore, instead of transferring the claim case in question, granted the petitioner therein to withdraw the same and to pursue the claim case pending before learned tribunal at Kojbihar only. Fullstop. Next para. The said proposition is the correct proposition of law. Fullstop. In any event, comma, nothing prevents the petitioner herein from not pressing stroke withdrawing his application under the Motor Vehicles Act pending at Jalpaiguri with leave to proceed on the self-same cause of action in the Kojbihar case. Fullstop. However, comma, there is no scope of invoking section 24 of the Code of Civil Procedure. Stop. Accordingly, after hearing both sides, CO 60 of 2026 is dismissed with liberty to the petitioner to withdraw the motor accident claim case filed by the petitioner at Jalpaiguri, being MACC number 457 of 2024, pending before the Motor Accident Claim Tribunal, comma, fast track court at Jalpaiguri, with leave to proceed with his other application, that is MACC number, that is also 457.
No, Lordship.
You have stated here
64, Lordship.
in the first title. See what you have stated.
46 in paragraph 7, my lord, written.
Lordship, I have annexed the
with the to leave to proceed with the
MACC
application on the self-same cause of action filed at Kojbihar. Fullstop. No address to cost. Certified copies. প্রথমে দিয়ে the affidavit of sale filed to be kept on record. ওনার নামটা দেবেন। Please write in your slip that you are appearing for only one.
Grateful, Lordship.
Next.
Item number 4.
তবু দিয়ে দিচ্ছি।
No. By an order dated June 11, 2026, comma, last chance was given to the petitioner to move the matter, since that was the second occasion when none appeared to move the same. Fullstop. Next para. Even today, on second call, comma, none appears to move the revisional application. Accordingly, CO 62 of 2026 is dismissed for default without any order as to costs. Interim order, if any, stands vacated.
number 11.
None appears for the parties. এটা কি for the first time appear করছে? This is the second occasion when none appears for the parties at the time of call. এটা MSCC না? এটা কি? MSCC না তো? এটা কত নম্বর? আচ্ছা, MSCC নষ্ট করবো না তাহলে। যেটা বললাম সে পর্যন্ত থাকবে। Let the matter stand over till the stand adjourned till the next circuit.
May I indulge, Lordship?
Yes.
So with regard to item number 6, I was on my legs.
Six have passed some order.
Lordship, there was a
Dismiss or default?
Lordship,
Six dismiss or
I
default?
informed by my learned colleague that was not dismissed for default. The last opportunity was given by my Lordship to file the reply.
Yes, you are right.
Lordship,
Last opportunity.
last opportunity was given. Lordship, may
I'm waiting for the last opportunity. You don't come on that date and dismiss.
Lordship, actually, the fact is that my draft is ready. The deponent is in
I
Chennai.
passed an order. Whenever on the next day, be present and say that.
Lordship, Lordship. Yeah.
Number 12.
Well, this appeal has been filed by the petitioner claimant actually. So against the managing director NBSTC, Northern State Transport Corporation.
You have given a notice to them.
I have already given a notice, but I have actually I have not received the acknowledgement. So I could not prepare
Come back in the next circuit.
next second. It will later.
Then counsel for the petition appellant submits that the intended service on the respondent has not yet returned. So accordingly, on the prayer of the appellant, let the matter stand adjourned till the next circuit. Next.
Number 13.
In item number 13, my lord,
Yes.
actually, there are two appeals actually. One is preferred by the claimant, the FMAT MB 65 only
The
2020.
other is appearing.
Other Mr. Borman is there.
No,
Actually,
no, the other
today-
matter is appearing in the list.
not appearing. My humble submission before lordship, since there is another appeal, FMAT MB 36 of the 2023. So since it is appearing from the self-same judgment, so let both the appeals be analogously heard together.
What did I ask you? Is it appearing in the list?
No, not in this list. Only,
Then I'll
only
direct
one
that.
matter
That
is
is the
appearing.
purpose for which I am asking. What is the number of the other appeal?
Other FMAT, 36 of the 2023.
2020?
3.
Achha. Learned counsel for the appellant submits that another appeal filed by the insurance company against the self-same judgment being FMAT within bracket MV, sorry, what is the number again?
36 of the 23.
Being MV 36 of 2025, 2023 is also pending. Whoso accordingly let the said appeal be listed along with the present appeal on when?
Next circuit, my lord.
Next circuit.
Next circuit, and affidavit of service is there, my lord.
Be listed next. Be listed in the next circuit.
Next circuit, kindly record one line.
আচ্ছা প্রথমেই তাহলে
Affidavit
সবকিছু
of
যা বললাম
service.
তার আগে add করো affidavit of service filed to be kept on record. Learned counsel for the appellant submits that the matter may be taken up in the next circuit along with a connected appeal. তারপর যেটা বললাম ওটা দিয়ে Yes, next.
Item number 14 with 15.
My lord, I'm appearing. There are two appeals, my lord. Both the appeals are appearing in the list together. So now come to the.
So I am for the respondent in the first appeal.
and appellant in the other.
In the, actually, there is an application for CAN 2 that has already been disposed of and I have complied. Accordingly, matter may kindly
It's
fix for
appearing
the
in the
final
list,
hearing.
showing in the list, though it has been disposed of.
And
So what is required to be done? Paper books are prepared.
Paperwork
No, no, no.
prepared, lordship.
no,
Paperwork
I have
prepared.
prepared.
In your
yes.
appeal also paper book has to.
Yes, I
Only your
recover-
memo has to be incorporated.
Lord,
Yes,
absolutely, absolutely, lordship.
Actually,
I-
Lordship,
Lordship,
LCR
look at
has
the
not
legal
been
law.
called for in the meantime. So fix the next circuit for
Lord,
you.
lordship, it is, so the actually the difficulty is that, my lord, in this case, the petitioner.
Your friend is not ready, he is wanting in next circuit.
Well, my lord,
Actually, it
let me
was
allow
not
to
fixed for
submit.
hearing today.
Actually,
Final
what
hearing.
happening actually, it's this case is traveling from one circuit to another circuit, and what happening?
The previous
No.
cases in which you asked for adjournment also are traveling from circuit to circuit.
Which one, my lord?
Previous one, the one before that.
No, actually, there are two appeals, my lord. Both the appeals today, by the strength of the order of the
This case of
lordship,
25.
will be hard together, actually. But this is older compared to that one, lordship. The older, lordship. And
Their appeal was older in the previous
Yes,
one,
1923.
1923.
lordship, what actually,
Your
what-
learned friend is following, he says yes.
lordship,
Yes.
actually, real difficulty is that, lordship, the petitioner is
This is item which? 14 to 15.
14, 15, lordship. What happening actually in this case, lordship?
No, you exchange your paper books, you file your paper books, you give a copy to them, let
Lordship,
them
I-
come prepared. If they're not
I
prepared,
have
what
to
is
file.
the?
Kindly fix it on Monday, lordship. Kindly fix it.
No,
What
it is
happened, actually,
impossible, lordship.
actually, one of the, he will not survive. Because he has not received even a single thing. They have not complied the order of the learned tribunal. They have not,
Well, come back
complied
next
order.
week. I'm keeping it on say Wednesday.
Lordship,
Tuesday.
I shall
Tuesday.
not be available on Wednesday. I'm just Monday, Tuesday, I'm available, lordship. I'm going
So
to Delhi.
Tuesday I'm keeping it.
Tuesday. At the top of the list, lordship. Within days. within-
That will be the only matter maybe by Tuesday, the way I'm going in
No,
single.
there
bench.
are other matters already fixed on Tuesday.
Oh, there are other matters that fixed in
Only
single.
My matter is there, lordship.
What's it?
So that's a little bit worried.
If your
lordship.
matter, no.
It will not
All
be-
your matters cannot be. You
But
cannot
this
have a
matter-
monopoly in court.
Actually, what happening actually in this matter, why I'm giving special emphasis particularly on this matter, lordship. The petitioner is actually the members of the family are calling me time and again because he is very serious. Even he does not have any single thing for the treatment, medical expenses.
Very well. I'm
And he
keeping
has
it on Monday.
Monday, lordship. Kindly.
Keeping it in the list on Monday, not at the top, but on Monday.
Within 10, lordship.
Monday, wait. I don't know whether 10 matters will be there in Monday. থাকবে অত? থাকবে না অত?
Grateful, lord, deeply grateful.
Actually, lordship,
Deeply.
Tuesday would have been better for me. But
No,
he's
but
seeking
that
for
will be
Monday
just
by
very
weekend.
tight.
I'm going to
Because if it
Delhi actually for medical purpose, lordship. My father is suffering from carcinoma.
Then the next circuit would have been, I have to.
No, actually,
I'm answerable.
Come, let us see.
with all my fairness, I'm submitting, lordship.
A copy of the paper books filed today in court be kept on record. For sub next para, the learned advocate for the insurance company is requested to serve a copy of the memorandum of the insurance company apostrophe S appeal to the learned advocate for the appellant in the present matter during the course of the day. For sub next para, the matter will be heard on the paper books as well as such the copy of memorandum. Both appeals will be heard together on the basis of such paper book and memorandum. When it is next taken up, full stop, let the matter stand adjourned till June 15, 2026. Let it be in the list. Please give a copy of the memorandum today itself to them. Next.
Deeply grateful, lordship.
Memo, I have already supplied.
Applied?
A memo.
You have a memo?
I've already got the memo.
তাহলে ওই জায়গাটা কেটে দাও মেমো অন সার্চ মেমো যেখানে করেছি একটা জায়গায় সার্চ করেছি ওটা and the memorandum of the other appeal.
Deeply grateful.
Other appeal এর নাম্বারটা দিয়ে দিও তন্ময় না তাহলে তো একসঙ্গেই করছো দুটো
Both are analogously.
তাহলে আদার আপিল যেখানে যেখানে বলছি এফএমএটি নাম্বারটা দিয়ে দিও হ্যাঁ আর এফএমএটি তাহলে যেখানে বললাম যে ইন দিস আপিল যেখানে বলছি দিস আপিল বলে ওনার আপিলটা দেবে মানে যেটা হচ্ছে প্রাইভেট পার্টি যেটা হচ্ছে প্রথমটা 76টা 76 হচ্ছে দিস আপিল যেখানে যেখানে বলছি আর আদার আপিল যেখানে বলেছি চোলামণ্ডলমের যেটা অন্যটা
Grateful.
থ্যাংক
Bill number 16.
And 17 both analogous cases.
আচ্ছা
On behalf of the appellant.
16 17 দুটোই দেখো
Item number 17.
who is for the respondent You have
This one I have just deposited the statutory amount. I need.
oh send then next circuit on the prayer of the learned advocate for the appellant let the matter stand adjourned till the next circuit এটা আলাদা আলাদা করে 16 17 দুটো দিও give your name please 18 দেখো
Item number 18.
মেসিসি কি ইন্টারেস্ট নেই এখানে আমার কোটে কেউ করে None appears at the time of call. Let the matter stand adjourned till the next circuit. আগের সার্কিটেও টাইম নিয়েছে করতে চাই না ফাইল করে দিয়ে
Item number 19.
I have put the appellant.
ভেরি গুড
As per direction of the. Oh, sorry.
হ্যাঁ appeals are paper books have been directed
No.
should I direct paper books then because in this manner it cannot be done there is no application
No.
Well, affidavit of service filed today be kept on record. Despite service, none appears for the respondents. Full stop. Accordingly, the appellants are directed to put in postal cost and requisite for service of notice of the appeal on the respondents through court, comma, within a fortnight from date.
As per direction of this honorable court, I have made.
No,
service upon-
this is not sufficient. If this is a shortcut, if they appeared, then it would be fine. If they don't, you know the rules we have to. Within a fortnight from date, push up the trial court record shall be brought by special messenger at the cost of the appellants, also to be deposited within a fortnight. So next para, the appellant shall prepare and file the requisite number of paper books within 6 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants, who have liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. Thank you. You are Mr. Bhattacharya?
Online.
Thank you.
Yes.
Thank you.
Item number 20.
What is the defect, ma'am?
Yes, there have been some defects and lordship, there is,
Defect is section 5.
yes, section 5.
You have not filed section 5.
Yes, lordship, we need some time to file a section 5.
On the learned counsel for the appellant seeks an adjournment for the purpose of filing a condonation application. Full stop. Accordingly, let the matter stand adjourned till next circuit.
Grateful, lordship.
Item number 21 with 22.
Yes, Mr. Sarkar.
Lordship,
Cholamandalam is the biggest player here. Yes,
Mr. Bhumik is there for them.
he is the biggest player among you. Yes, what about this paper books are ready?
application.
Huh?
I have a
Section 5. Reason for delay, Mr. Sarkar?
Lordship, the wife and two minors, actually, they have no idea. They came to me after getting notice of their appeal,
What is the period of delay?
146 days.
Recording your objection and allowing?
Yes, yes.
The petitioners, comma, being a housewife, comma, her daughter and minor son of the victim, comma, have preferred the present appeal, full stop, in view of the ignorance of the appellants regarding their rights, comma, and as well as the fact that they are financially indigent, comma, the appeal could not be filed in time. Full stop. Learned counsel, heard learned counsel for the, upon hearing learned counsel for the parties, comma, sufficient explanation for the delay in preferring the appeal is found to have been proffered, PROFERED. Full stop. Next para, accordingly, can 1 of 2026 is allowed, thereby condoning the delay, allowed on contest, comma, thereby condoning the delay in preferring FMET bracket MB 33 of 2026. Full stop. No address to cost. Paper book directions should be given.
Grateful.
Is there anyone else to be served, owner or somebody else? So then you'll have to put in postal cost for that. Insurance company service.
I have already filed affidavit of service.
Affidavit of service won't do that. Notice of appeal has to be served.
Then I shall serve.
And this affidavit of service regarding section 5.
Lordship, I shall serve.
In view of the appearance of the insurance company through their learned advocate, service of notice on the insurance company is dispensed with. Full stop. The appellant shall put in postal cost and requisite for service of notice on the respondent number 1 within a fortnight from date. Full stop. The trial court record shall be brought by special messenger at the cost of the appellants, also to be deposited within a fortnight. The appellant shall prepare and file the requisite number of paper books within 6 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants, a liberty to the parties to mention the matter for enlistment as and when the same is ready for hearing. Thank you.
Grateful.
Oh,
22, Lordship, I am the appellant and where Can
No,
1 and Can
it
2
has
has
to
already
be-
been disposed of.
to do
Lordship,
এটা 21 ক্ষেত্রে
TCR called for.
আর 22টা হচ্ছে 22 is your appeal. You also have to put in the poster, they are appearing. So
Yes,
in-
they are appearing
In
in that.
their case also, the owner has to be served. Very well. এটা
I have served the,
তুমি না
মানে
ওখানে কোথাও একটা করে দিও 22 ক্ষেত্রে আছে তো ওটা যেরকম অর্ডার করলে একসঙ্গে লিস্টে অ্যাপিয়ার করছে তো একসঙ্গে অর্ডার করতে হবে। ওটা যেরকম করলে তাহলে এটা বলছে এই নোটিশ অফ অ্যাপিল করে নোটিশ অফ দি অ্যাপিল বেয়ারিং বলে প্রথম 21 নাম্বারটা দিয়ে দেয় FMA 48 of 2026 আর তারপরে লেখো insofar as FMA 30 of 2026 is concerned comma the appellant shall furnish a copy. It's against the self-same judgment.
Yes, yes, yes.
Shall furnish a copy of its memorandum of appeal on the learned advocate appearing for the appellant in FMA 48 of 2026 by May 15, 2026. First up, the appeal shall be heard on the said copy as well as the paper books to be filed in FMA 48 of 2026. First up, the insurance company, that is the appellant in FMA 30 of 2026, shall put in postal cost and requisite for service of notice of the appeal on the other respondents than the respondent number 1. There is only one respondent, other respondent.
I hope so. Yes, one. We have received notice.
On the respondent number 2.
Actually, owner is not contested in the trial court also.
Not contesting.
Owner. Actually, policy.
In the previous matter, তাহলে ওটা করতে হবে। তাহলে postal cost এর জায়গাটাই উড়িয়ে দাও।
Policy was valid
Postal cost
accordingly,
এর
did not
জায়গাটা
contest.
postal cost I'm just deleting. আর একটা লাইন অ্যাড করে দাও postal cost এর জায়গায় যেখানটা ডিলিট করে আগেরটাতে তার জায়গায় ঢুকবে in view of the appearance of the respondent insurance company through their learned advocate. না সরি সেটা তো আগেই বলেছি কোথাও একটা বলেছি ওইখানে অ্যাড করে দাও আরেকটা সেন্টেন্স সেম প্যারা since the other respondent stroke owner did not contest in the trial court comma service of notice of the appeal on the said owner is also dispensed with and the appeal be treated to be ready as regards service. আর এটার ক্ষেত্রে করে দাও FMA 30 টা insofar as FMA 30 of 2026 is concerned comma ও যেটা আচ্ছা আমি বলে দিচ্ছি the learned advocate for the insurance company stroke appellant shall furnish a copy of the memorandum of the said appeal on the learned advocate appearing for the respondent number 1 by June 5th already given. এটাও করে দাও insofar as FMA 30 of 2026 is concerned comma
I am appealing. I have filed Bhukalan also.
The same will be heard along with FMA 48 of 2026. আচ্ছা আগেরটা যেটা বললাম না পেপার বুকসটা বলেছি না prepare and file the requisite number of ওখানটা করে দেবে composite paper book both for FMA 48 of 2026 and FMA 30 of 2026. You will prepare composite paper book, just add their memorandum, the rest is same.
Thank you. Grateful. Thank you. Grateful. Thank you.
Item number 23, 22.
Yes.
My lord, for item number 23, I'm appearing on behalf of the respondent.
Yes.
And for item number 24, I'm appearing on behalf of the appellant. My
Right.
lord, both are the analogous matter which are arising out of the self-same judgment.
Yes.
My lord, for the item number 24, there is like 553 days of delay in filing the appeal, and hence the CAN application is being filed today. My lord, since we have filed the CAN application today, kindly keep the matter on Monday or Thursday next week so that we can have the
Give
necessary
a copy to them also. You are appearing for the
Yes, my lord.
insurance company.
Yes, my lord.
Very. On the
Grateful, my lord.
prayer of learned counsel for the appellant in FMAT within bracket MV 27 of 2026, comma, in order to enable the appellant to file an application for condonation of delay in filing the appeal, comma, let the matter stand adjourned till June 17, 2026, when it will next be listed under the same heading. It will appear under the same heading. In the meantime, you file your section 5, give a copy, mention it. Mention the application so that it can come.
Grateful, my lord.
Thank you.
Item number 25.
দেখি এটা not free করে দেখতে খারাপ লাগে ফাঁকা হয়ে যাচ্ছে none appears for the parties at the time of call let them attend adjourn for the day
Item number 26.
My lord, I am on behalf of the appellant. There is direction filing,
paper book
paper.
file it and there is a copy to them
My lord,
for the court acha already filed
already filed.
previously or filed
My lord,
acha very good. So when can you come prepared
my lord, 18. Next week, my lord.
Next week, my lord.
Monday.
18th, my lord.
18th means I won't have any time to deliver judgment so then next Saturday.
Monday, my lord. My lord, Monday.
A copy of the paper book is handed over here and now by the learned advocate for the appellant to his counterpart appearing for the respondent. Who's the next para? Let the matter stand adjourned till June 15, 2026.
My lord.
Thank you. Monday.
Get to my lord.
Give both of your names, please. Yes.
Item number 27.
দেখি সেকেন্ড অ্যাপিল কেউ পেপার বুকস আছে এটা কি অ্যাপিয়ার করছে দেখুন পেপার বুক দিতে হবে না জাস্ট সেটা এই বেঞ্চে না কথা হলো এটা নট রিকোয়ারেবল none appears for the parties at the time of call let the matter stand adjourned for the day চলো ডাকো চলো আস পড়ে যাও